We are now broadcasting and recording.
Are we ready to call to order?
Yes. Yes, ma'am.
All right. Good morning, everybody. We're glad to have everybody here via Zoom this morning. And we're going to call this meeting of the Texas Behavioral Health Executive Council to order at 9:05 this morning. Our next item is the roll call and certification of a quorum. Ms. Fletcher, are you going to call the roll for us?
Yes, ma'am.
Thank you.
Gloria Canseco. Sarah Abram.
Yes.
John Belamowitz. Timothy Brown.
Present.
Steve Christopherson.
Present.
Susan Fletcher.
I'm present.
George Francis.
Excitedly here.
Megan Graham. Jennifer Smotherman.
I'm here.
Madam Chair, you have a quorum.
All right, thank you.
Camilla, if you don't mind, Megan Graham's no longer representing the social work board on the council. Ben Morris is, and he's here with us.
Good morning.
Good morning. Thank you.
Good morning, Mr. Morris. Thank you for being here with us today. It's good to see you.
Thank you. You too.
Daryl, I thought I saw John on the call. Is he here? Did we miss him?
Yes, he's on the call.
Okay.
John, are you muted? Yeah, we can't hear you.
Okay, I can see his face, but I can't hear his voice. All right, he's going to get it
Hold on.
fixed.
Yeah.
All right. We do need to have a motion to excuse the absences. Our chair, Gloria Canseco, is not able to be here today due to another situation. And so can I have a motion to excuse her absence today?
I make a motion to excuse her absence.
Second, George Francis.
Thank you. Thank you. So that was Dr. Abraham who made the motion, and George Francis the fourth who seconded that.
Yes.
All in favor?
Aye.
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 Okay. Did I miss any other absences? Do we need to excuse anyone else? That's it.
That's it.
All right. So our next item on the agenda, item number 3, is public comment. And I do want to encourage everyone that we have a limit of 3 minutes for our public comments today per person, unless we are able to, unless we say otherwise. Please keep your comments to 3 minutes. We want to be sure, the reason for that limit is we really want to be sure that everyone is heard. We're in dealing with rules today, we have a lot of people who are interested in speaking, and we want to be sure that we have time to hear all of you. So we ask kindly that you'll respect that 3-minute limit. Can you help me walk through that, Daryl, in terms of who and when? And I can't see the public on here.
If the attendees who are the members of the public who would like to make a public comment, please use the raise hand feature on the Zoom meeting, and I will start going down the list and unmuting you so that you can give your public comment. Those of you that have telephoned in, once we've gone through all the attendees with their hands raised, I will then unmute all of the people that have telephoned in and ask you whether or not you have any public comment to give. So, okay, and ladies and gentlemen, when you do give your public comment, I would ask that you identify yourself, give us your full name so that we know who's giving the public comment. And if I miss it, Ms. Fletcher will correct me, and you as well. So, okay. Dr. Silverman?
Yes, can you hear me?
Yes, sir. You would
Yes, my name's Edward Silverman. I'm a licensed psychologist in Houston, and I've conducted more than 550 court-ordered child custody evaluations over the past 32 years. And I can think of relatively few family experiences that are as stressful as going through a contested child custody dispute. It's devastating to parents when they firmly believe that the outcome is detrimental to their children. And furthermore, it can be infuriating if it appears that the outcome was influenced by a seriously flawed custody evaluation. Clearly, litigants in this scenario are entitled to sufficient recourse, and the public needs to be protected from incompetent evaluators. However, a disproportionate number of board complaints involve child custody evaluations, and I'm concerned about complaints of questionable merit that are based strictly on the outcome of the litigation rather than the quality of the evaluation. The virtual inevitability of a board complaint has dissuaded newly licensed psychologists from specializing in this area, and the cumbersome process of undergoing multiple board complaints has experienced custody evaluators questioning whether they want to continue on this career path. The net result has been a serious lack of qualified evaluators, which is delaying the resolution of contested custody cases by several months, sometimes upwards of a year. This is clearly not in the best interest of these families, emotionally or financially. The public deserves the availability of high-quality evaluations conducted in a timely manner, and I think modifying the procedure for resolving board complaints is an important component of achieving this goal. The proposed rules for complaints related to court-ordered evaluations address these concerns by allowing complaints to be triaged based on the documentation that is provided. The information that's required in subsection D is extremely reasonable and should be readily accessible to the complainant. Dismissing complaints that do not comply with this subsection will be cost-effective, and it will allow investigators to focus their resources on the complaints that warrant the most attention. Subsection F is an excellent way of differentiating legitimate complaints from complaints that are based strictly on the outcome of the litigation and not on the quality of the evaluation. Now, some may view these rules as barriers that will make the process more difficult for the complainant. But on the contrary, I believe that subsection F provides the complainant with clear guidelines regarding the type of supporting evidence that is considered important, while ensuring that all complaints that are factually based will be investigated. And furthermore, this subsection provides investigators with a clear set of guidelines for how to proceed. So the entire process becomes more objective, more data-driven, more transparent, and more efficient. I firmly believe that the proposed rules reflect the board's sensitivity to all of the stakeholders who would be affected by them, while maintaining the primary objective of protecting the public and ensuring that evaluators who are not following the rules and laws that govern their practice will be held accountable. Consequently, I strongly support their adoption, and I thank you for the opportunity to speak to you.
Thank you, Mr. Silverman. Dr. Silverman.
Ms. Kotler? Ms. Kotler? Ms. Kotler, did you want to make a public comment? Okay. Ms. Stewart, did you have public comment to make?
Yes, I do. Can you hear me okay?
Yes, ma'am.
My name is Harmony Stewart, and I'm a second-year graduate student in the counseling program at St. Edward's University. And I'm a member of the TCA, but I'm representing myself today. I appreciate the opportunity to speak to you about the importance of mental health professionals sustaining their ability to work with diverse populations through continuing education. I understand the individual boards represented on BHEC hold the responsibility for setting continuing education requirements for each respective behavioral health profession, and I appreciate the goal of consistency across those rules when possible and appropriate. Given the complexities and long timelines for adopting rules, my hope is that by bringing this issue to your attention today, you may decide to help expedite the process. Although coursework to develop cultural competencies is part of all our curricula, only psychologists are currently required to complete CE hours in cultural competency for their license renewals. My request is that representatives of the LPC, social work, and LMFT boards bring back a recommendation to their respective boards to adopt a similar rule. In the midst of one global crisis, another has reached a boiling point as a population of marginalized individuals cries out for their lives to be valued, because Black Americans are still enduring regular violence and delegitimization. And the mental health community is obligated to lead by example and respond with compassion. Considering the long history of racial trauma in America, I feel it would be ethically considered best practice for us as mental health professionals to continuously prioritize deeper cultural understanding and foster collective healing as part of our standard of effective care. Therefore, as a future clinical mental health counselor, I urge you to recommend that your respective boards add cultural competence CE requirements to qualify anti-racism curricula to the rules before they are published. I appreciate your time and consideration.
Thank you.
Mr. Brahms or Brahms? Mr. Brahms, did you have public comments you wanted to make? Okay.
Can you hear me?
Yes, sir.
Yeah, I'm sorry about that. I apologize. Still technologically a little bit behind, I think. Yes, thank you so much to the board for allowing me to speak. I just wanted to speak informally about some experiences on my own behalf. I'm not calling to represent anybody but myself. I am Andrew Brahms. I'm a psychologist in the Houston, Texas area. And I had some informal comments I wanted to make about a few things that I've experienced with some of the clients who I've referred to other professionals in the community. Just some things to bring to your attention that I've done some research on, as well as has had just professional experience with, is two to three particular areas. One is that I've had clients who have been sent to other practices and have been assigned, if you want to call it, to certain clinicians who are not being licensed but have been supervised or in supervision. And there is no indication on their business cards nor in some of their social media information that they are currently being served or serving as an intern being supervised by a licensed clinician. If you go to the LinkedIn sites and so forth, if you want to look, you'll see that there are a number of people that use social media and do not indicate that they are an intern, nor are they well, they do sometimes indicate they're an intern, but it isn't until later or into some other digging that you find out that they're actually supervised and that they list the supervisor's name. So that is something I think that is something that might need to be investigated. I know myself as a psychologist, but if I supervise somebody, I'm going to expect them to be very specific and to follow the ethical guidelines in reference to what it is to deem yourself as an intern. The second thing I wanted to address, which I'd like the committee to deal, is with handicap access to providers. I have referred people who have been physically challenged to other providers in the community. They go to their place of business, which sometimes is a home or some type of freestanding place that has been updated and so forth, and they do not have access to those resources, especially getting up to the front door, nor if they have a second floor, there is no elevator, there is no way to breach that barrier, if you want to call it, so they're able to provide services. And so I've had some frustrated clients call me back who say, I can't get in, I can't call. I even had one client who said that the person was going to charge them because they missed the appointment, and they tried to call them from downstairs but could not reach them. I have had people indicate to me that there's something about references in terms of the city codes and so forth, that they're not required to do it because of I'm not exactly sure, but they came up with some kind of excuse. But as a board, I find this to be disturbing that there are people who have physical disabilities that enter these places that are structured not like a typical building, which usually is ADA compliant that you rent. And these clients find these barriers to be able to enter the place, nor to find or to gain access to second floor, third floor suites, if you want to call it, so that they can get services provided to them. And this has been a disturbing issue, which I have seen, unfortunately, more times than I can count. So I would appreciate the board to address these issues at some point in either clarifying that in the laws or in the ethical guidelines, or somehow in some way being able to justify that if you are a clinician, that as a clinician, you have to somehow prove that where you are is ADA compliant and that your clients have access to you, in a very feasible manner. So if you could take those into consideration, I would greatly appreciate it. Thank you so much for hearing me.
Thank you.
Okay, TCA committees. Hello, is anyone from TCA committee?
Yes, I'm here. Can you hear me?
Yes, ma'am.
Sorry. Hi, I'm Jan Fries. I'm representing the members of the Texas Counseling Association, and we really appreciate all of your hard work and the opportunity to work with you. I want to thank you for incorporating so many of the rule changes we requested at your last meeting. That said, in consideration and support of BHEC's limited role to create operational efficiencies and prevent federal antitrust violations, there are a couple more rules we ask you to consider revising. In section 881.21D, please add language to specify that petitions for rule changes related to scope of practice, ethical standards, and standards of care be forwarded by BHEC to the respective board, just to make it clear that BHEC cannot solely evaluate those petitions. It doesn't hurt to include this language, so those following in our footsteps will know how these petitions should be handled. Reports on times for processing license applications in section 882.9A must be broken out by license type. License processing time was one of the biggest motivators for HB 1501. Given the diversity of license types within each of the professions housed at BHEC, a composite report will not provide adequate and appropriate transparency on the actual time to process a specific license. We are very confident that these reports are going to be great, so why not share the good news? We ask you to change may to shall in section 884.12C to require consultation with individual boards on contested enforcement matters. Consultations don't need to be cumbersome, but they will help maintain the appropriate roles of the member boards and BHEC. The benefits of engaging each board far outweigh potential processing delays and in fact might even save time. We also strongly recommend changing section 882.70 to reflect how Texas currently handles emergency licenses. The language proposed by our coalition exactly aligns with the procedures in place to address the COVID pandemic and will make us very agile in future disasters. I've been advised that our request that I was submitted in writing regarding anti-discrimination language will be reflected in a resource document on the BHEC website, so we'll let that comment stand for now. And then finally, I'm unable to comment on the proposed rules for the Texas State Board of Examiners of Professional Counselors because I have not yet seen the version of the rules that are before you today. I thank you very much for your consideration and your service to Texas, and we look forward to continuing our very productive and cooperative working relationship with you. Thank you for your time.
Thank you, Jan.
Daryl, if I could cut in, please. Can you hear me? This is Ben Morris.
Yes, sir.
Okay. I still have my audio, but I have lost video, and it looks like it is labeling me now as a post attendee.
You're still here. We can hear you and we can see you.
You can see me. I cannot see you.
Let's see here. Okay.
Mr. Spinks, if we wouldn't break any rules, my recommendation would be for Mr. Morris to log out and log back in and see if that can solve the issue.
All right. All right. I'm going to log out and then I'll log right back in.
Okay.
Okay, now my prompt is saying I'm already in another meeting. Do you want to leave and join this meeting? Yes or no?
Say yes.
All right, very good. Thank y'all.
That's why we pay Mr. Francis the big bucks.
Excellent.
Your $30 check for the year will be in the mail, George. All right. Next up, Dr. Growthuse, can you hear me?
I can hear you. Can you hear me?
Yes, ma'am. Go ahead.
Mr. Spence, I appreciate it. My name is Dr. Carol Growthuse. I'm a licensed psychologist speaking on behalf of the Texas Psychological Association regarding rule language on 65.2 supervision. We believe that TSBEP intended to expand the use of synchronous audiovisual technologies for supervision, which we applaud. But the language seems to be drafted has a couple of concerns. For one, new language also would allow an entire supervisory relationship to take place over the phone, which we don't think is a good idea. You lose too much information just on the phone without the audiovisual requirements. And I don't think that that's what they intended, but it could read that you could have that relationship completely over the phone. It also lost possibly asynchronous methods like email, which may no longer be allowed, and I don't think that was intended also. So we're asking for BHEC to send this rule back to TSBEP so they may examine the language in more detail. If this is truly what TSBEP intended, then they'll send the language back to you, but we suspect our concerns with these drafting errors will be shared by the members of TSBEP and corrected. We just want to be sure that that's not an unintended consequence of the language.
Okay.
Thank you.
Ms. Bradshaw?
Yes, good morning. Can you hear me?
Yes, ma'am.
My name is Christy Bradshaw Schmidt, and I'm a licensed professional counselor. I've worked solely in the field of family law as a child custody evaluator and expert consultant for 2 decades, and I've conducted over 575 child custody evaluations. I've also served as the mental health liaison to the Family Law Foundation, where I've worked with countless others on the drafting and passing of legislation that impacts Texas families and mental health professionals alike. I'm also a member of AFCC in the family law section. First and foremost, I want to thank y'all for your time and your dedication to serving the citizens of Texas, and I want to provide my overwhelming support for the additions to the complaint process that have been passed by the Texas State Board of Examiners and Psychologists in relation to child custody evaluation complaints. I believe that this process allows for protection of the citizens of Texas while also ensuring that complaints to the board are limited to issues of licensure and not court outcomes. I've heard from those who oppose these changes that there are 2 things that are needed. The first thing I've heard is the need for additional regulations and requirements for child custody evaluators. And I want you to know that it already exists in the Texas Family Code, Section 107, Subchapter D. This law was originally passed in 2015 and expanded upon in 2017. This law took over 6 years of work to draft and pass, and Texas now has one of the most stringent laws related to child custody evaluations in the nation. The second thing that I have heard is needed is some form of citizen oversight board. And while I certainly appreciate this need, I believe that this need has already been met by all the mental health boards as they exist today, including your council, where public members are represented and heard. I also think it's important to point out that, as I believe you will hear and has been stated in other public meetings for other boards, that there's a dearth of child custody evaluators throughout the state, and this has resulted in evaluations taking longer, which is not beneficial to families. The citizens of Texas need and deserve to have competent child custody evaluators, and until the process of board complaints is addressed, as has been done by the psychology board, I fear that our field will only continue to dwindle. Child custody evaluators often become the focus of one parent's complaints and concerns during the midst of litigation, and it's important to remember that there is a legal process where those complaints and concerns are to be heard. I also work consistently as an expert reviewing the work of other child custody evaluators, and I often have the opportunity to provide testimony to the court, to assist the judge or the arbitrator in determining if the contents of an evaluation are reliable and valid. It is ultimately up to that trier of fact to make this determination if families have been unable to resolve their disputes on their own through mediation or settlement discussions, and the judge or the arbitrator needs to help Texas families resolve their disputes first before any possible ethical issues are reported to the board. The statute that exists within the Family Code provides the court, the attorneys, and the litigants involved with clear explanations as to what should and should not be included in evaluation. Please know that I support the changes that have been approved by the Psychology Board. I'm hopeful that the other mental health boards will consider similar requirements in the future. And I again want to thank all of you for your time, your commitment, and your dedication to this process. I think it's vital that the public be protected and that subpar child custody evaluators be held accountable. We appreciate all of you. Thanks so much.
Thank you.
Ms. Karsagi, did you have some public comments you wanted to make?
Yes, I do. Can you guys hear me?
Yes, ma'am.
Yes.
Excellent. So yes, I just also want to say thank you again for allowing me to speak. I've spoken both to the Executive Council and also to the board several times. Some of you are very familiar with me and also with my case. I'm coming to you again today because, of course, we are in the same situation. I heard a lot of custody evaluators speak today, and I think that there seems to be a misconception between what the issues actually are. And this is not disgruntled parents who are unhappy with an outcome. This is protective parents who are genuinely concerned about the failure of the system to protect the children. I'm a firm believer that in a custody evaluation that it is less about the parents' rights and more about the child's safety than anything else, and that this should be tantamount to everything else. And unfortunately, I have not seen where the child's best interests have been the standard thus far, particularly in my own case with Dr. Kim Arredondo. I will cite for you the example that there have been multiple Child Protective Services investigations that have been ongoing for the last year and a half since my ex-husband got sole custody of my two sons, both of whom were diagnosed with autism and have communication issues which bar them from being able to functionally say what is happening to them. And despite all of the evidence, both in the court as well as since the final order was issued, CPS continues to close all of their investigations, citing Dr. Kim Arredondo's fraudulent report. This is a huge concern because my children have no one to protect them and our voices are being silenced multiple times. We're very concerned. I recently learned that an 846-page complaint to the TSBEP board put together by amazing lawyers and PhD psychologists who are experts in their field and who were concerned about Dr. Arredondo's report was dismissed. And I would reiterate again that the concern is for the safety of the children. 5 black eyes in less than 6 months is too many. I have the photographs. I've shown them to the board in the past, and they have been shown to CPS as well. But CPS continues to look to Arredondo's report. And this is something that's very misleading and that is resulting in the children being in a terrible situation. My children cry out for help. I have another audio that I would like to play that this has been recorded just since I last spoke with you all, if you would listen. Abba means daddy. And this is what I go through each time that I'm able to see my children. And I understand that I'm approaching my 3 minutes, and so I would conclude with this. Every time I see my children, they have horrific injuries. Every time they scream and they beg, and I pry them from around my neck, and I force them to go back to a situation that I know is an abusive situation because I lived that. I'm a survivor of domestic violence. I got out, and my children didn't. Through several failures of the agencies that are supposed to protect us, my children ended up in a horrific situation, and we have been begging for help. This has nothing to do with malice or vindictiveness, and it has everything to do with just trying to protect the kids and just trying to keep them out of this situation. Their voices deserve to be heard, and we need help. And it is because of Dr. Arredondo's report that we're not being heard and we're not being listened to, and we have grave concerns. And I would ask for the council to step in and to do something to help these kids. It's not right that they would be raised in this environment. I'm very concerned about that. I'm very concerned about the injuries, and I think many people also are. Recently, the supervising agency announced
Ms.
that they will.
Karsagi,
Yeah.
excuse me. We're at about 4.5 minutes. Can you please end your comment? Yes.
Yes.
Please.
I would just say that the last thing that I would say is that they have decided that they're no longer going to allow any photographs to be taken, which means that there will be no further evidence of the abuse, and that this cover-up is a big part of the problem. So thank you, and we ask for your help.
Thank you.
Mr. Craig, did you have some public comments you wanted to give?
Yes, Mr. Spinks. Actually, I have Wanda Patrick here with me too. If both of us might be able to give our 3-minute comments, that would be very much appreciated, sir.
Okay.
Okay, I'll let Wanda go first. Thank you.
Yes, thank you very much for my opportunity to speak here today.
What's your name again, ma'am, so that I can make sure we have it?
Wanda Patrick.
Wanda Patrick, okay.
Yes, can you hear me?
Yes, ma'am.
Yes.
Yes, thank you for my being able to speak before you today. I am going to agree with everything Ms. Karsagi has to say, as I have also filed a formal complaint of several hundred pages with the Enforcement Division of the TSBEP. And this may be my only opportunity to speak to you before a final decision is made regarding my formal complaint. My family and I are victims of Dr. Kim Arredondo as well, due to her many inappropriate relationships and clear conflicts of interest, namely her 20-plus year close relationship with my ex-mother-in-law. Dr. Arredondo has went so far as to pursue me and continue to harass my family as well as an employee of my family's long after her report was issued. My son Shane, who spoke at the last TSBEP meeting and was allowed to present his videos that he did so he could get his thoughts presented more clearly, is being treated for severe malnutrition by Texas Children's Hospital due to the inability of his father to meet his nutritional needs. There's clear documentation of his weight gain when he's with me and clear dangerous weight loss when he is with his father. He just turned 19. At 19 years old, he weighs only 92 pounds. I'm very concerned about the possible permanent damage this obvious neglect will cause. During a court hearing, several people witnessed Dr. Kim Arredondo making unwanted physical contact with my son Shane, despite his repeated requests that she immediately stop. She did this not once, but on 4 different occasions that day, after he told her to leave him alone and go away. Dr. Ardondo's treatment of my son that day in court speaks to the unethical way in which she conducts herself professionally, which extends to her biased reports. Over the past several years, I've watched my son fight to succeed despite facing impossible odds. I've watched a frightened young man develop into a mature, responsible young man determined to have his voice heard. Our case is now in guardianship court, where Dr. Ardondo's report is once again being used. The decision that will be made regarding our complaint with the TSBEP will have a lifelong impact not only on our family's future, but on this young man's life. I'm very concerned that the TSBEP board will not revoke Dr. Kim Ardondo's psychology license, so I'm calling on the executive council to intervene and ensure that this travesty that has happened in our cases as a result of Dr. Kim Ardondo is addressed, and that the TSBEP board is held accountable for ensuring the protection of the public. Due to the continuous egregious behaviors of Dr. Kim Ardondo, and in the interest of the protection of the public, I strongly urge the executive council to be involved in ensuring that appropriate action is taken to undo the damage done, protect others, and get the children returned to safe parents. Thank you very much for your time.
Thank you.
Hello, this is Jim Craig. And my comment is kind of unique in the fact that I am Wanda Patrick's boyfriend, well, a longtime friend, known her for about 6 years. And I've watched this saga kind of from the outside in, but now I've become inside. And it was interesting to find that in reading Dr. Arredondo's report, that although she has had this long working and personal friendship with Wanda's ex-husband, that she was still allowed by a TSBEP board member to do this psychological social study. And the ethics in that concerned me. And I wanted to address the board about this, because if there's nothing in your guidelines or in your bylaws in the ethics section about having one side being friends with a licensed practitioner, psychologist, and having them be unduly favored or not favored, that right there concerns me. And I don't know if anyone's had a chance to read Dr. Arredondo's report, but one of the board members is listed in the beginning of her report as being approached and agreeing to allowing her to have that ability to conduct this exam, although she was very, very good friends with, in this case, the abuser in the family. The other issue that I've got is, since I spoke last month as well too to the TSB board, and I was very grateful for the opportunity, like I am now at the executive council. Since my last talk, Dr. Arredondo has contacted Wanda's ex-husband, brought him into her office, and sat him down and placed Alyssa Karsagi's ex-husband's phone number on his phone, encouraging those two gentlemen to communicate in order to help her with her complaint, the multiple complaints that she has. The reason that I know about that is because Shane, who is both Glenn Patrick and Wanda Patrick's son, spoke to me and several people about this on multiple occasions, and has got him so afraid right now. He spoke last time to you. I think you remember his video and his photos. He's upstairs in bed in a fetal position under the covers, because he knows that we're on this call right now, and he is afraid for his life. I don't know what else to say other than I really truly hope that our concerns for the children, don't worry about the parents. I'm not worried about the parents. For the children's sake, I hope and I pray that the board will take these complaints against Dr. Kim Arredondo seriously and review the evidence and go by that, and hopefully you'll come to a conclusion that what has been happening is a pattern, a long-standing pattern of abuse using her reports. In both Wanda Patrick's case and also with Alyssa Kasagi's case, Dr. Arredondo's report was the only evidence admissible and allowed in court. All other evidence provided that would totally refute the report was disallowed by the judge and has ended up costing massive emotional trauma, massive physical trauma, massive nutritional trauma in the case of Shane, and it is devastating to the kids. And I just pray and hope, and I'm begging Executive Council to please, please, please take this report seriously. Please take these complaints seriously, and please look at this. This is not a disgruntled he said, she said. If you'll look at the facts and you'll actually examine the report, I pray that you'll come to the same conclusion and that you'll come back and help save these children. I thank you.
Thank you, Mr. Craig. Thank you.
Dr. Rob, did you have public comments you wanted to make?
Yes, sir. Can you hear me okay?
Yes, sir. Loud and clear.
Excellent. Thank you. Good morning, everyone. I'm Dr. Aaron Robb. I am a licensed professional counselor with degrees in both counseling and in social work. As somebody who is professionally bicultural, I particularly appreciate the challenges that BHEC faces in working with its multiple member boards and their different guild traditions. I want to thank you for your efforts and your hard work there. Tens of thousands of behavioral health licensees serve millions of clients every year. We hear from some issues and some areas more often than others, but in general, I want to voice my support for rules proposed. They appear to target the operational goals that BHEC has been given for efficiency, timely action, and transparency. I want to particularly thank BHEC for the candid response to the request to cut 5% of their budget from the governor's office. We must advocate for full funding if we expect timely resolution of issues and protection of the public. I want to note my area of expertise is working with high conflict families. I provide a variety of court-connected services, and I serve on the editorial boards professionally of the Journal Family Court Review and the Journal of Family Trauma, Child Custody, and Child Development. I have spent my professional career first with Child Protective Services, then with the family courts in Dallas County, and now in private practice across the North Texas area. And my focus has always been on trying to reach the best interests of children out there. As others have noted, there are multiple points of review regarding child custody evaluation and every other forensic assignment out there that mental health professionals become involved with. Evaluators are not the court. Judges and juries weigh information and are the ones deciding final outcomes, not evaluators. It should not be the place of licensing boards to review the work of judges and juries. That is what the appellate courts are there for. Failures of the court and CPS are not the purview of BHEC or the member boards. When these failures occur, they are indeed tragic, but this is the wrong forum for addressing such issues. I've testified in cases of child custody evaluators who have failed to meet their standard of care, who have failed to act in the best interests of children. And I have to say, it is not the length of a complaint, but the clarity and the ability to show where their error has occurred that are most critical. The new rules that are proposed focus in on this. They should allow for targeted complaints when there are errors that member boards and BHEC regulate, and they should be able to address quite clearly and quite quickly the members of the various boards who are in need of remediation. We appreciate that BHEC has gone through these efforts, and we appreciate BHEC is trying to do their best with their limited role in serving and protecting the families in Texas. Thank you very much for your time.
Thank you, Dr. Rob.
Ms. Whittington, did you have public comments you'd like to make? Ms. Whittington?
Can you hear me?
Yes, ma'am.
Okay, sorry. Thank you very much for letting me speak today. And I did send you a letter on June the 5th that will have more information that I'll be able to give you in these 3 minutes. But I thank you for your time and effort. And I'm speaking in support of the rule change. First, a little bit about me, because I think it's important. I've been practicing family law since 1987.
Ms. Whittington, could you give, I'm sorry to interrupt, could you give us your full name so that Ms. Fletcher can
Oh, I'm sorry. It's Susan Rankin Whittington. And I was on the family district bench for 12 years as Susan Rankin. I've married, but it's Susan Rankin Whittington. I come to you as a board certified family law practitioner, a judge in the family courts. And then also, before I went to law school, I attained a master's in clinical psychology, where I testified in custody cases after I'd done the psychological evaluations. What I was surprised when I was asked to look at this issue was that there was not really a threshold, or there was a minimum threshold that a litigant had to meet to be able to make a mental health professional file a response, because these kinds of complaints are numerous in family law cases. And other areas of the practice have limitations and structure to the complaint process. To give you an example, and I called the Commission on Judicial Conduct to make sure this was still accurate, they once told us that there are files of complaints against family lawyers. Would you like to see them? Which was a surprise to us, because very rarely does it rise to a level where you actually have to answer the complaint. There's a process that it's screened to see if there's a judicial misconduct, and if it's not alleged, then they dismiss the complaint, but they don't dismiss it until they take it to another forum to be checked out one more time for public protection. That should not be an issue that the judge has to take their time to answer. There are safeguards in the system. Aaron Robb and Christy Bradshaw have eloquently stated the family code has strict, very specific provisions as to what credentials you need to have, what experience to be able to even be considered to be a custody evaluator. And as Dr. Silverman and everybody's saying, it's getting fewer and fewer number of professionals that even want to embark on this process, because family law is emotional. When there's an outcome that a litigant doesn't like, sometimes they want to find somebody to blame. They look at the evaluator, they look at the judge, they look at their lawyers. And so there's got to be structure to this process. And first of all, because you all might not know this, someone files a motion to get a custody evaluator appointed. They can either agree to one or the court appoints. But again, there are specific instructions that were just credentials reviewed in 2015 and 17 will be on that list. And then as Dr. Robb explained, if the outcome isn't like you like it, the evaluator came out for the other party, you might say, then in the legal process, you can hire your other expert to come in, like Dr. Robb said, and say, this wasn't handled correctly, or I don't think this was the best way to have done that. And so you're teaching the judge or the jury whether they should rely on that custody evaluator's opinion, that it's not just a slam dunk for the evaluator to say who gets custody. That's up to the jury or to the judge. I guess I just wanted to say I do like the structure that you all are imposing to protect everybody, because the public is protected. There are many safeguards put in place to be able to assure that the person that's doing the evaluation is qualified and that it's presented to the legal system correctly. Some of the problems, as you all know, might be that a person doesn't get in the evaluation into evidence, and that's not the evaluator's fault, that's the lawyer's fault. And everybody has to follow their own rules and guidelines. It's a highly charged area, and that's what I mean, I feel for the folks I've just been listening to. I know nothing about their cases, but I know that they truly believe that their children are being harmed. But these proposed rules will give more safeguard to the public because it will structure the complaints and keep frivolous complaints from taking the time and distracting the evaluators from doing their job. Thank you very much. I appreciate it.
Thank you, Ms. Whittington.
Stephanie G., did you have public comments you wanted to make?
Yes, I did. Can you hear me all right?
Yes, ma'am.
All right. Let me first say that I and many others are present today to ensure the integrity of the profession of psychology so that the public can rely on these services. This is a goal that we all share. I have my undergraduate degree in social work, and I went into this process with the utmost respect and trust in mental health professionals. I was shocked at the misconduct I experienced with Dr. Alyssa Sherry. The public is not adequately protected by the rules and the laws and the processes that are in place currently, or we wouldn't all be here discussing this issue affecting so many families. I filed a complaint with the Board of Psychology against Dr. Sherry in May 2019 because I don't want what happened to my family to happen to any other families. My complaint is still under investigation and I don't know the status of it. We know of nearly 50 cases in which Dr. Sherry made wrongful diagnoses and engaged in a variety of misconduct. Of the 16 known complaints, and there may be more, against Dr. Sherry, the Board of Psychology has dismissed 10 with no disciplinary actions. Another 6, including my own, remain under investigation. I am certainly fearful that mine is going to be dismissed as well, since that seems to be a pattern that I would like investigated. Not all citizens submit complaints due to fear of retaliation from the practitioner, among other reasons. Many of these complaints that are submitted to TSBEP had other licensed professionals, experts, identify Dr. Sherry's wrongful diagnoses and misconduct. Yet the Board of Psychology continues to dismiss these complaints. And we want to know, how is this repeatedly happening? Families are torn apart by incompetent evaluators. Children are removed temporarily and even permanently from parents due to false information from unscrupulous or untrained evaluators. I am pleading for reforms to prevent evaluators from wrongfully destroying families. We need more rigorous regulation of court evaluators, transparency, and accountability. The Board of Psychology is, in essence, self-regulating. There's a conflict of interest. There's no independent oversight of its investigative functions. Psychologists, whether reliable or unreliable, are given power with the court's trust as well as legal immunity. The evaluators need specialized training and stronger requirements. The Board of Psychology appears to be both advocating for its licensees while also investigating them. That appears to be a conflict of interest. We are asking you, the council, as well as our legislators, to form an entirely independent investigative body and citizen advisory board to eliminate the conflicts of interest. Judges follow the evaluators' recommendations, whether they are wrongful or valid, because the judges see them as experts. And they're very costly. So to say that a family can go in and get a second opinion, you're looking at $20 to $50 to even $100,000 of additional money to refute a wrongful report. Then after that, evaluators are given legal immunity as well, so that there is actually little to no recourse for citizens. Finally, I and many others oppose the proposed rules regarding the complaints. It's simply an opportunity to dismiss complaints without ever investigating them. These rules don't include many of the reforms that we've been asking the Board of Psychology for well over a year now. Without stronger regulation of forensic evaluators, there is no prevention and families will continue to be torn apart. These are systemic problems that require—
Excuse me, Ms. Gee. Excuse me, we need to go ahead and finish.
Okay. We are asking you at the BHAC to do whatever you can to stop this from happening and prevent it from happening in the future. Thank you so much, and I apologize for going over.
Stephanie,
Thank you.
what's your full name so that Ms. Fletcher can put it down in the record?
Sure, it's Gibson, Stephanie Gibson, GIP as in puppy, SON.
Thank you, ma'am.
Thank you.
Elizabeth Vasiri?
Yes, Elizabeth Vetchery.
Oh, I'm sorry.
No worries. Thank you very much for the opportunity to speak today. And I find it very interesting listening to comments from both counselors and psychologists and also from parents with their experiences. And I think there's kind of an assumption on all sides from what I'm hearing that the system is perfect and as long as we follow it, that, you know, it's going to work. And in theory, that's correct. But what it doesn't account for is human fallibility and human character. And I think that is the complaint that needs to be addressed, and why people are coming to this board with things that, you know, certain people might consider not appropriate to bring before this board, such as the case with Dr. Kim Arredondo and Dr. Sherry. And the reason for that is because there's a lot of corruption in the system. And that is what needs to be addressed. It's not that the rules are the problem or that the system is incorrect in its setup. It's that there are human errors that are causing problems and causing children to be in situations in which they are not safe. And it is very concerning for me to hear, as a personal friend of Alyssa Karsagi, somebody who knows her for a very long time. She helped raise me as a child, along with my 6 other siblings. I know she is very capable of taking care of her children and keeping them safe. And to hear her going through the situation, it breaks my heart, honestly. And it should break the heart of every parent that hears it, of situations like this, and situation, I believe the name of the child was Patrick Craig, or Craig, and however was the last name. I don't remember the name of the young man going through his situation. But I just want to reiterate that the system is supposed to protect people, not protect abusers. And that is what we are bringing before the board today, to consider these situations in which the system is clearly not working and it is broken. It needs to be evaluated on a case-by-case basis. I'm not advocating, you know, that it should be entirely scrapped. That doesn't make any sense at all. Systems are in place to protect, and when they're not working and they're clearly broken, things do need to be looked at on a closer basis, and words can be twisted, and, you know, people can be manipulated and paid off, and that's just a part of human character. And we need to look at the situation and decide deep down whether, when you see something, whether inherently it is right or wrong. And I think that's something that this year is bringing to, hopefully, to all of our attention. And I thank you again for this time to speak before you, and thank you for listening.
Thank you.
Miriam Grinstein. I hope I pronounced that correctly.
Yes. Yeah, my name is Miriam Grinstein.
Okay.
Yeah, I'm here to speak about the Alyssa Karsagi case and Dr. Kim Arredondo, just to testify to Alyssa's character as a caregiver to other children that I've seen her engage with. So I find it really impossible to believe that she would be unqualified to take care of her children. And I think, it's been brought to my attention that this ruling was made as a result of an evaluation by Dr. Kim Arredondo, and I believe that that needs to be revisited strongly. And I am speaking on behalf of her children. Thank you.
Thank you.
Victoria Harvey, did you have public comments you wanted to give?
Yes, can you hear me?
Yes, ma'am.
Wonderful. Good morning. My name is Victoria Harvey, and I'm a psychologist who's been licensed with Texas since 2012. And I wanted to speak this morning to voice my full support for the proposed rule changes regarding complaint processes with custody and forensic evaluations, which have already been passed by the Psychology Board. I've attended previous board meetings, and I've heard the emotional stories from those who are dissatisfied with the outcome and process of these types of evaluations. We do seem to all agree that forensic evaluations and custody evaluations are important. And although others may not be able to fully conceptualize it, we mental health professionals do want evaluators who violate the Texas Family Code or violate their licensing board rules to be held accountable. I firmly believe that the proposed rules will actually enhance the board's ability to identify these quote-unquote bad evaluators and provide appropriate remediation. The accounts that we hear by those opposed to the proposed rule changes are compelling. And while we sympathize with their distress, the facts of the issues cannot be ignored. The repeated demand for guidelines regarding evaluator training ignores the fact that the Texas Family Code clearly spells out these requirements for evaluator competency, including specialized training and supervised evaluations. As a PhD level practitioner, it took me 2 years, in addition to the 7 years of graduate training specializing in forensics, to meet the requirements of competency. The call for a Citizens Oversight Committee also seems redundant and seems to miss the fact that the licensing boards, including the board that already passed the proposed rule changes, has private citizens as vital members of their boards. Having such a diverse membership ensures that the voice of the public is represented. The allegation that the board is protecting its own is simply inaccurate and seems to be dismissive of the invaluable contribution made by the board's public members. The complaint that evaluators wield unchecked powers regarding the fate of these families being evaluated also appears to ignore the fact that evaluators are subject to rigorous cross-examination, are often reviewed by other experts, and the ultimate decisions lie with the judges and sometimes even a jury of their peers. The assertion that litigants should be able to file board complaints during active litigation seems to dismiss the fact that attorneys and litigants are currently able to exploit the complaint process to remove evaluators from cases when they feel the case is not going in their favor. This not only slows down the process, adding considerable time and expense to the litigants, but it is depleting the pool of lawyers willing to do this kind of work. I believe we are all striving for the same goal of having evaluators held to the highest standard. And I believe that the proposed rules for the complaint process will help achieve that goal for the public who is directly impacted by the work that is done. Thank you.
Thank you.
Ms. Weinstein, do you have public comments you'd like to give?
I do. Can you hear me?
Yes, ma'am.
Thank you. Good morning. My name is Krista Weinstein. I appreciate the opportunity to provide concerns about the child custody evaluation complaint process and my support for the recommended changes. I have the unique context of having gone through 2 Dallas area custody evaluations in 2.5 years. These 2 experiences were dramatically different. The first evaluation took less than 3 months. The report was both inappropriate and contained extensive non-factual information. The evaluator's conclusions were drawn from stories not substantiated, opposed to the submitted evidence. I later learned that the evaluator did not follow the Texas Family Code. Like myself, the majority of people going through a custody evaluation are not trained evaluators. To this day, I am not sure of all the infractions, but here are a few. More than one therapist was misquoted. There was no verification of facts, including by teachers, therapists, family members, police, and others involved. no checking of requested personal references. Post-report, I requested my psych exam be sent to my therapist. I signed the appropriate forms and called to follow up. More than 3 years later, it has still not been sent. Even knowing the report was inaccurate, at mediation, I followed the evaluator's recommendation and agreed to 50-50 custody. This proved to be disastrous for my children and for me. Almost immediately, the alienation and undermining intensified. During the next year, the verbal, emotional, and physical abuse against me and my property by all 3 of my children and my ex-husband was beyond anything I can put into words. My ex-husband was granted a TRO against me on false allegations, and he tried to get a protective order. The children lied to police, doctors, therapists, teachers, and administrators. By court order, 2 of my children were sent to therapeutic wilderness program due to my ex-husband's previous and current actions. The first custody evaluator did not hold him accountable for his actions, and he was given a pass to continue his abuse. This description demonstrates the severity of the results when a custody evaluation is not done appropriately. The evaluator performed both unprofessionally and unethically. The result was fateful. It is important for you to know that the second custody evaluator and evaluation were remarkably different. The process was as expected and completed within the time frame told. The family code was followed, and the report was fact-based, evidence-based, and thorough. The emotional and mental damage children and parents endure from a non-professional and unethical evaluation cannot be measured. We are real people, and the consequences are grave. I've spent literally millions of dollars trying to get help for my family, and I continue to fight to undo the harm that was caused. The progress is slow. It is essential for the public to trust the evaluator and the process. Allowing poor evaluators to continue their work with no consequences for unprofessional behavior undermines the entire process. For those of us who are dealing with abuse, it also gives false hope that our abusers will get help or be stopped. Additionally, professional, competent, ethical evaluators who follow the law need to be protected from frivolous complaints made by litigants who do not like the report. Those in high conflict cases must insist the evaluators be held accountable. It is essential that Texas families be protected. The rules under consideration provide for both. I appreciate your hard work and effort on behalf of Texas citizens. Thank you.
Thank you.
Ms. Tender, did you have public comments you wanted to make?
I do. Can you hear me?
Yes, ma'am.
Good morning, everyone. I want to thank you for holding Zoom committee hearings so that all of us can attend and speak our piece. And I appreciate your patience in hearing us all out. It makes it feel much more collaborative as a process. So I'm a clinical psychologist in the city of Houston. I can't be quite as articulate as my colleagues are, so I'm just going to be authentic and concise in hopes that it will make an impact. I'm one of 3 known custody evaluators in the city of Houston. And as you may have heard of our shenanigans lately with COVID, we have a massive population. We are drastically and detrimentally underserved as a population for our citizens. And we are a dying breed, custody evaluators are. And it is really important that good custody evaluators continue. And all of us are at risk. Those of us who strive to meet the standards who've already been highlighted by my colleagues who have spoken today are, I think, unintendedly, in an unintended way, impacted by frivolous complaints in the process. I wanted to highlight that the board, the TSBEP, is actually not there to protect us as psychologists. In fact, we have organizations such as the Texas Psychological Association to advocate for us as practitioners. So in contrast to that, the board itself is absolutely there to solely regulate our behavior and to protect the public in isolation. Unfortunately, that scares a lot of us off when it comes down to complaints, because we've heard how rigorous the process can be for those of us who violate rules. And so I wanted to make that clear to the committee members that this is not in actuality what's happening with the board. The board is there to protect the public. I also wanted to leave you with this idea that 3 of us in the city of Houston have been doing any of these for any number of years, and 2 of those people are retiring. We only open up the door for incompetent and unqualified evaluators when we can't get new blood into the field, new qualified people. I personally have spoken all across the state trying to recruit, ethically recruit people to come and do this work. It is simply not possible to do so with more hurdles to this situation. So thank you for your attention to this matter. I sincerely hope that you will support the passage of these rules that the board has already approved. Thank you very much for your time.
Ms. Bolware, did you have public comments you wanted to give?
Yes. Hi, this is Allison Moore-Bolware, and I'm the Government Relations Director for the National Association of Social Workers Texas chapter. And I appreciate y'all taking public comments. I know that via Zoom is a little bit more difficult than in person, so I appreciate y'all doing that today. So NASW Texas represents over 5,000 social workers across the state, and we've already submitted some comments alongside the other mental health professional associations that we've worked in collaboration with. So I don't want to go through all those comments, but I just wanted to highlight 3 main points today. The first being that we, as a group, would really like for y'all to consider our suggested language for subchapter G related to emergency temporary licenses. The COVID pandemic has really shown us how important it is for providers to need some flexibility for those emergency temporary licenses to ensure that Texans can get the needed mental health services that they need. And again, that it be appropriate and with a licensed professional that has been vetted by our council. So we really hope that y'all take those comments into consideration, especially based on the current pandemic that we are seeing. My second comment is related to what we have heard about the BHEC website having a non-discrimination language clause really prominent on the Behavioral Health Executive Council website. NASW Texas applauds that, and we really know that for both the providers and clients, especially LGBTQ plus Texans, that this really means a lot, that y'all are going to put this up front and out there on non-discrimination for both the clients and providers. So we thank y'all for that. My third comment is a little bit tougher to talk about. So we have heard from a lot of our members, especially since COVID started, that what has already been a backlog from our board on new license issuance and approval to take the exam, as well as supervision plan approval, that there are more backlogs than usual, some of them going back 4 weeks and some even farther back to March. And we've even heard from some of our members that have submitted items back in 2019. So as you can imagine, our members are frustrated. They're very frustrated, and it feels like this is preventing some of them from working, you know, because a lot of jobs require that you have a license to begin the job. We also know that the board has been doing all that they can. We know that they have had issues with understaffing. And so we really want to say that we know that this is not any one person's problem, but we really know that this is an issue that has been plaguing our board for a while. So that leads into my final comment, is that we know that the board, the licensing fees for social workers are going to go up. And we know that this is going to frustrate social workers across the state just because there's not been any change to how the board has worked or the backlog. So it's really tough for us to explain to people why the fees are going up without anything to show for those changes. So we ask respectfully that y'all consider delaying increasing the social work fees, either 12 months or until we can see some results from BHEC. Because we know that BHEC is going to make these changes that will really help the administrative burden and be more efficient. So again, we're not faulting the board staff. We know that this has been a chronic issue. And so we really just want to take the time to show y'all that our members are really dedicated to this. We've created a task force with some really passionate students that are trying to get their license right now. We've been talking to legislative staff about this, who've heard from a lot of their constituents who are having these issues. We've also been talking to the governor's office about this. as well as the board leadership. And so again, we know that there are times where the board hasn't had the proper tools or ability to provide what they're asking for, what our members are asking for and other social workers are asking for, which is a license. So right now we really just see increasing licensing fees without showing direct results to be an issue for our members. But again, we appreciate all that y'all do. We know that this is a really tough time to be doing this job. We're all hearing from all different folks with a ton of new issues because of this pandemic. So I so appreciate y'all listening to my comments, and I'm here to answer any questions that y'all have. And thanks again for taking public comments today.
Thank you.
Ms. Kotler, you have public comments you'd like to give? Ms. Kotler, you're still muted. Okay. Ms. Axelson, you have public comments you would like to give?
Yes, ma'am. Yes, sir. Can you hear me?
Yes, ma'am.
Good morning. My name is Tammy Axelson, and I'm a licensed master social worker with the Independence Practice Recognition in the state of Texas. I just wanted to introduce myself and let you know that I work as a full-time child custody evaluator, and I'm in the rural areas of East Texas. I began conducting child custody evaluations in 2006, and I've probably completed about 120 evaluations to date. I wanted to let you know that not many child custody evaluators in Texas are actually social workers, even though we are qualified to do them. I've been spent years conducting these evaluations in rural areas, with the majority of my clients actually being low income. My goal and my role as a child custody evaluator is to be neutral, in which I essentially function as the eyes and the ears for the court. And I work to assist the court in determining what's best for the children involved. Just to clarify too, as an evaluator, I don't make decisions or rulings for children. That's actually the role of the court. But my goal in writing these reports is to provide information that clients or parents might not have the chance to share in testimony, as well as important data. And I work to make sure that all of my conclusions and recommendations to the court are based upon research and to aid the court in understanding child development and family systems. In my practice, a high percentage of my child custody evaluations actually assist the families in settling their disputes without going to court. And that is an enormous benefit because it reduces the cost of litigation, but it also protects the family unit from further conflict. As we all know, divorce and issues regarding child custody of children frequently results in families and children experiencing strong emotions and distress. It makes our field for the mental health professionals who work in this area difficult for us. We have to navigate the balance between protecting families while also maintaining the focus on being the best long-term outcomes for these children. Unfortunately, as many others have said, there's a huge need for qualified child custody evaluators in East Texas specifically, which is very problematic to our families and our court system. The Texas Family Code actually has some exceptions to the educational requirements of child custody evaluators, that these can be waived in court in small counties under populations of 500,000. However, even if the court waives these educational components, the evaluator is still absolutely required to follow all the statutes and the laws and elements outlined in the Texas Family Code. I have been training evaluators, and I'm really pushing to find those who will continue to work, especially in these rural areas of East Texas. And we definitely need more qualified and good child custody evaluators to help our families and to help our court system. I just wanted to express to you that I personally am thankful for the time you've committed to understanding our process and our field of child custody. It's a difficult thing to understand, and I appreciate your work in developing these guidelines for the complaint process. It's important that we absolutely maintain high standards for evaluators, but most importantly, that we protect the public and people from bad evaluators. And I just wanted to say in conclusion that I fully support the process that was adopted by the Texas Board of Examiners of Psychologists. And I really hope that other boards, like specifically my licensing board for social workers, will follow suit. Thank you so much for your time.
Thank you.
Mr. Simpson, did you have public comments you'd like to give?
I do, yes, thank you. Good morning, members of the council. Thank you for the opportunity to speak today. My name is Michael Simpson, and I live in Denton, Texas. I'm testifying today to echo Ms. Karsagi, Ms. Patrick, and Mr. Craig in calling on the council to direct an investigation into Dr. Kim Arredondo. In the case involving Ms. Karsagi, Dr. Arredondo in 2019 delivered a biased and factually incorrect report that resulted in the nearly complete separation of these children, one of whom at the time was still breastfeeding from their mother, Ms. Alyssa Karsagi. Since that time, Ms. Karsagi has gone weeks and at times months without seeing her children. During what visits she has been granted, she has observed signs of physical and potentially sexual abuse to both of her children. In addition, she has audio recordings of her children begging to not be returned to their father, many more than she played for you today. In each instance, CPS has opened and subsequently closed investigations without so much as a phone call to Ms. Karsagi. I say all of this to illustrate both the tremendous unchecked power given to custody evaluators and the dangerous outcomes it can cause. Now, based on public comments you've heard today, it seems Dr. Arredondo is encouraging two parties from completely separate cases to collaborate in her defense. At best, this is a gross violation of the privacy of those involved, and I would hope the council also recognizes the possibility of an ethics violation. This alone should be grounds for an investigation. With respect to Dr. Silverman's and Dr. Tinder's earlier testimonies, no one voicing concern today is doing so about competent custody evaluators who serve their communities well. That said, all custody evaluators should be held accountable to defend their findings. If this council can prevent even one instance of gross injustice, if this council can prevent even one child from being wrongly separated from their parent, if this council can prevent even one child from imminent danger due to the incompetence of a custody evaluator, we should all agree that is a worthy cause. Thank you again for your time and for your service.
Thank you.
Ms. Wright, did you have public comments you would like to make? Ms. Wright?
Excuse me. My name is Peggy Wright. I'm a licensed professional counselor and board approved supervisor. I serve as the director of sexual assault and counseling programs for the Fort Bend Women's Center in Fort Bend County. I've been working in the field of domestic violence and sexual assault pretty much since before I became licensed during my practicums and internships. So about 20 years. That it also included whether I was in private practice and contracted with domestic violence agencies or worked at domestic violence agencies. I've been working at the Fort Bend Women's Center for 11 years, but prior to that, I worked at domestic violence prevention in Texarkana for about the same amount of time. Throughout my career, I have noticed that many of my clients who had custody battles were losing their custody battles. And we often question why women don't leave their abusers, and that if they don't leave their abusers, that they are somehow complicit in the abuse of their children because they don't leave. However, what we're finding is when they do leave, they lose custody. There is a systemic problem in our family court system, and I personally have been working on a training for family court judges and have been researching this issue for over a year because it has been brought to my attention by several clients. And I have also served as an expert witness both in civil courts and criminal courts related to domestic violence. I will say that about 97% of the cases, family custody cases, are not contested and don't result in lengthy trials. However, about 3% of those cases are contested, and the legal world calls these cases high conflict. What we know is most of these high conflict cases involve domestic violence or child abuse or sexual assault of the children. And what we're finding out is there is systemic evaluator bias in the courtrooms, and oftentimes these court evaluators do not have enough training in domestic violence and sexual assault, and they're seeing it as he said, she said cases, when what we're really talking about is protective mothers trying to protect their children from ongoing and further abuse. Recently, Joan Myers completed a study that provides empirical evidence for the gender bias in courtrooms. There's also bias against victims in general because their word is not taken as seriously as the abuser's word. We have children dying from homicide and suicide when they are given, when the batterers, the abusers, are given custody of these children. Some of these children are running away, some of them are abusing drugs, but it is creating a great deal of problems. We have protective mothers who have not seen their children in as many as 2, 3, 4 years because of the gender bias and victim bias in court evaluators. And as far as I can tell, there is no oversight for these decisions, and they don't have nearly enough training in the field of domestic violence, which I consider a specialty area, much like you would not want somebody who is a licensed medical doctor, maybe board certified in OB-GYN, you would not want them doing brain surgery. I don't think just because somebody is a licensed psychologist or any kind of licensed mental health worker, that gives them expertise in the field of domestic violence and sexual assault. And in my opinion, they're practicing outside of their school.
Ms. Wright,
And
we need you
thank you
to
very
end your
much for
comments,
letting me
please.
speak. I'm done. Thank you very much for letting me speak.
Thank you.
Ms. Falkenberg, do you have public comments you would like to give? Ms. Falkenberg? Okay. Kasim Hitzroni, do you have public comments you would like to give?
Hello, good morning. My name is Kasim Maya Hitzroni. I have been an educator for the past 14 years, and I am a mother of 5 children living in Houston, Texas. I want to thank you for the opportunity to speak today. I feel it's at least something small that I can do for a woman who I very much admire, Miss Elisa Karsagi. I deal with education. I deal with children on a daily basis in my private and professional life. I'm also a summer camp counselor. I deal with hiring staff. I've been around the block a lot when it comes to education and children and safety. And upon meeting Elisa Karsagi, I saw that she is an incredible educator. She's patient, she's understanding, and she's just fantastic and loved by children. And the more that I delved into her case with her children, being a friend, there's a lot of legalities that I don't understand. But as a mom living in Houston, when I see what's happening to her, I'm petrified, because if that can happen to one woman who's so fantastic with children, it can happen to any of us. And I know that we are hearing many different opinions and voices on today's meeting, but there definitely, maybe there's not something wrong with the system as a whole, but there is definitely something wrong with the custody evaluation that was given to Elisa Karsagi, and the evaluator must be held accountable. Our entire community loves and knows Elisa, and I trust her with my children more than I would trust any other person outside of my immediate family. My children love her. She's safe. She's very, very careful, responsible, caring, and understanding. Anyone who would take away the custody of Elisa with a child is someone with either a personal vendetta or who has psychological issues themselves, because it makes no sense. And I'm saying this from the perspective of an educator and a mother who cares deeply about the children that are entrusted to me. And I don't know what changes need to be made across the board, but I definitely know that the custody evaluator in Elisa Karasagi's case must be looked into and her license revoked, because there has been a horrific mistake in this situation, and it should not happen to anyone, especially such a wonderful, good, kind, and loving person like Elisa.
Thank you.
Ms. Friedman, did you have public comments you would like to give?
Yes, I would. Can you hear me?
Yes, ma'am.
Okay. My name is Diana Friedman, and I'm an attorney and licensed in the state of Texas. I've been licensed for 28 or 29 years. I practice exclusively in the area of family law. I am a former chair of the Family Law Council and former president of the Texas Family Law Foundation. I've also served on our legislative committee for, I don't know how long, probably 15 to 20 years. And I've served as co-chair on that committee for many years as well. This area of law, I think, is one of the most difficult ones there is. It's very emotionally charged. You're dealing with people's families, with their children, and it's extremely difficult for courts, litigants, and for lawyers. If without this, and not that anyone's suggesting we shouldn't have this, but without the statutory scheme that we have now, judges sit in a courtroom and hear a story from each litigant and they don't know what to do. And so that's why we have these child custody evaluations, as the court appoints someone who they believe to be competent to go in and interview everyone, look at all the information, and make recommendations. There were no guidelines in effect until several years ago, and that's where some of my colleagues and I started looking at the issue, saying there's no guidelines, there's people doing these evaluations who are unqualified. One person's evaluation doesn't look like another person's evaluation, and there's not really good standards. So we went to work, and this was a huge project. It took 4 years to get the statute passed. It went through a lot of sets of eyes. We got input from people all over the country. In mental health wise, we talked to lawyers, we talked to psychologists, we talked to various groups that had interest in it, and it was a very long, lengthy process. It was vetted very heavily, lots of revisions made, and it's not perfect, but it has vastly improved child and custody evaluations in Texas. I think that the proposed rule changes that you all have are very good, and I would support those. And while I hear people saying, and I sympathize with them, that they feel like they got a bad evaluation, I don't think the rule changes are the issue there. Both sides have their viewpoint of what happened. The child custody evaluator does their job. There are provisions that address bias, whether they know a party or not. So I know that was brought up earlier, but I want to make sure that everyone knows that this child custody statutes do address that issue if someone has a conflict of interest. But once the evaluation is complete, there's layers to this. Yes, judges give it a lot of credibility because they know that this is someone who's gone and done a lot of work. But I have, as a lawyer, had judges and juries disagree with the evaluation. So the child custody evaluator is not the one making a decision. And sometimes clients feel pressured to make an agreement because they don't want to go through a trial. And that's an issue in every case. But the statutes that we have in place cover a lot. And so I want to make sure that it's clear that the evaluator doesn't make the call. The clients can reach an agreement. If not, it can go to a judge. In Texas, it's only one of 2 states that allow a jury to hear these cases. So a litigant has a choice. Only one person has to make a request for a jury, and then a jury can hear it if they think that the judge won't be fair to them. And then after the trial, if they're not happy with the result or they think there was something wrong, there's also an appellate process. So there's many layers to it. It's not perfect, but in the vast majority of cases, it does work. And I would also point out, someone mentioned earlier, most cases don't even have a child custody evaluation. The vast majority of people who get a divorce reach agreements without having to go through this process. So only the most difficult cases are the ones that go through the child custody evaluation. And so I think that the requested changes that you have and are very good, and that the process should not be interrupted midstream for a complaint, because that's an abuse of the process too. And so you should let the evaluator finish the process, let it take its course, and then if there was abuse, come back and fix it there. I don't think there are I don't think there's very many cases where that happens, but that's, in my opinion, is the best approach.
Thank you, Ms. Friedman.
Ms. Kamen, did you have a public comment you would like to give?
Yes, please. Thank you very much. My name is Lynn Kamen. I am a board-certified family law attorney in Harris County. I have been practicing family law for over 30 years and have been part of the Family Law Section Legislative Committee for 20 years. As Ms. Friedman just testified, I also was involved in the drafting of 107 of the Family Code. And the reason that we did that is because we were concerned that the public, the litigants, were not being well served because there were no strict standards for custody evaluations. One of the persons who just testified talked about the issue of domestic violence. Under 107 of the Family Code, it is required that someone who is conducting a child custody evaluation have courses, current courses, and be educated in the area of domestic violence. We are always going to have people who are not qualified as mental health care experts, as attorneys. But as an attorney, I have a responsibility, and so do all other attorneys representing people in child custody evaluations, to understand what 107 requires, to understand that if 107 is not being followed, that I have, as an attorney, the ability to cross-examine the expert, to ask that the expert be disqualified, to bring to a court, a judge or a jury, the parts of the 107 requirements that were not followed. So I think as an attorney, I have a responsibility, and so do all the attorneys who practice family law. I think the mental health care experts who put themselves on the line to do these evaluations put hours and hours of time into it. Yes, sometimes they're wrong. I don't agree with them all the time. In fact, some of the speakers who have spoken today, I don't agree with all the time. But I do know that they do their job diligently, and they police other evaluators who are not doing their job. So I support what is before the board today, and I encourage citizens who have complaints to talk to their lawyers, to make sure that they have an attorney who understands the requirements, because we have the same type of responsibility as the mental health care experts. Thank you.
Thank you. Mr. Spinks, at this time, I would like for us to take about a 10-minute break, and then we can come back and continue our public comments.
Okay. When we take a break, I would ask that all the council members mute your microphones and turn off your cameras.
Okay, thank you.
Because I will have to leave the meeting going, but just mute and turn off your camera.
Okay, we'll come back in about 10 minutes.
Okay.
Absolutely.
I know at one point we hit over 80 people, and that was very astounding.
That's remarkable.
Okay, I'm going to one up your adjective and go with spectacular then.
It's fantastic.
Tremendous.
Oh, no. Are we ready to call it back into order? I can't see everyone who's in here. Tamala, do we need to call roll again, or can we just go with the pictures that we can see on the screen?
I'm going to defer to council.
Okay.
I think you can just go with the pictures you have on the screen.
All right. It looks like everybody is back for the most part, and we will go back into this meeting. We're at 10:57, and we are still on item number 3, I believe, on public comments. And Mr. Spinks, I'll turn it back over to you to continue working us through this section.
Ms. Vasiri, do you have public comments you would like to give?
Yes, I would. Can you hear me?
Yes, ma'am.
Yes, my name is Michelle Vetchery, and I am a friend of Alyssa Karsagi. I have known her for about 14, 15 years, since about 2005 to 2006, when I asked her to babysit my 7 children at the time. She is a wonderful babysitter, friend, very kind, compassionate. I felt very safe leaving my 7 children with her, and I can't say that about very many people. She was the favorite babysitter of our children. I knew that my children would be healthy and safe and well cared for when she was taking care of them. I was very happy when I found out she got married and had her own children, because I knew she would be an awesome mother. And I was just devastated when I heard what was happening to her children, that they were taken away from her, one of them while she was still nursing. And now she has to endure these tumultuous times. She enjoys looking forward to seeing her children, but it breaks my heart to see pictures of bruises and cuts on them, where there shouldn't be bruises and cuts on children from normal playing, and hearing their cries to not go back to their father. It deeply concerns me that this abuse keeps going on in her situation and is not being addressed. So I plead with the Executive Council to please intervene to consider what this custody evaluator, Dr. Kim Arredondo, has done that is not right. And she's not reporting the facts that these children are being abused and taken wrongfully from Alyssa. I'm very concerned about the safety and well-being of her children and their future. being in the hands of this abuser. So I plead with you to please consider what they are going through. And as a mom, I know her heart is only to care for them. And the fact that they know who loves and cares for them, they're pleading to be with their mother and pleading not to go back to their father. We should listen to those cries of those children. They know when they're being loved or hurt or not. And please check into this Dr. Kim Arredondo to make sure she doesn't keep hurting these children and abusing her power. Thank you for listening to me today.
Thank you.
Okay, Ms. Kotler, we'll try one more time here.
Okay, can you hear me?
Yes, ma'am. Now we can hear you.
Great. Thank you so much. I had to resume. I had to get out and resume. My name is Bonnie Kotler, and I appreciate your giving me the opportunity to speak on behalf of Alyssa Karsagi. My husband and I are blessed with children and many grandchildren, and additionally, I have worked at the front desk of a pediatric office for some years with a wonderfully diverse group of parents and patients whom we treat as family. So I do feel comfortable speaking about parents and children. Here are 4 examples I'd like to share with you about Alyssa. Number 1, she has a high sense of integrity. If I try to pay her extra, she stops me or tells me, "Oh, I took a little break today. Please deduct that amount." At times when she was explaining what had happened to her and I would repeat back to her to make sure that I understood, she would softly clarify everything to make sure I did not say anything incorrect, even if it was for the benefit of the other person. She has a high sense of integrity and honesty. Number 2, when I asked my 14-year-old granddaughter if she knew my friend Alyssa, the first words that came out of her mouth were, "She's awesome with kids." Now, how many adolescents would speak that complimentary about someone? Indeed, I have seen Alyssa at different homes, playing games, talking with a handful of children all around her, from babies to adolescents. Number 3, one of my grandchildren, 6 years old, has a genetic disease. If he doesn't drink a cornstarch solution every 3 hours, the results are unspeakable. It's called glycogen storage disease. So one day, while caring for others, Alyssa saw him and noticed that he seemed sad and asked him why. He told her that he was having a bad day. He wasn't going to drink his cornstarch. He was just going to go to sleep. Alyssa knew what that meant. She said comforting words to him. She quickly phoned his mother and possibly saved his life, all because she noticed that he looked sad while she was taking care of other children. Number 4, sporadically, Alyssa will be allowed to see her 2 boys, often at a community center or a library. On 2 occasions, I was able to bring them pizza. And for a few minutes, when the door opened and I put the pizza down, I got to see her relating to her children. I saw that she had brought toys and books for them and had them around the room. She had one boy on her lap, a blanket for another one. They looked so happy. This is what gives Alyssa the most meaning in her life, to be with her young boys. And her love for them was tangibly seen in their love back to her. It was truly idyllic, and I left thinking how blessed I was to have had the opportunity to see them all so happy together. So the bottom line from these 4 examples is that it is really incomprehensible how Alyssa could be assessed as being in any way unsuitable. She is a most gentle, kind, caring, honest, very bright, and intuitive mother for her children. I understand that she had a custody evaluator, Kim Arredondo, who supported taking the children away from her and giving custody to the father, whose temper episodes and brandishing of a gun many times has been documented. He even admitted so by himself. Please, I'm asking this council to investigate this and to intervene, as I do worry for the physical, mental, emotional, and health and safety of the children. Thank you so much. The children are very young, and I thank you so much for listening to me today. Thank you.
Thank you.
That concludes all the the people that have logged in for public comment with computer. I'm going to begin with the phone calls now. Oop, we had one more. Come up. Tara, did you have public comment?
I do. Good morning. My name is Tara Coronado, and I want to thank you for the opportunity to speak. Earlier today, I sent an email to Mr. Spinks, which I hope was disseminated to the full board. When an evaluator and former board member feels emboldened enough to speak out publicly on behalf of the TB-SEP board, while soliciting support for her individual case, there is a systemic problem. This problem is exacerbated when the board then summarily dismisses multiple complaints against the former board member, particularly when there is no mechanism for appeal. I'm hoping that everyone has that email in front of them. That's a question?
It was disseminated, yes, ma'am.
Okay. So I want to add, I filed an MFT complaint in November of 2014. It was initially dismissed, but I appealed. Upon appeal, the investigator opened 2 new cases against the therapist, which were finally adjudicated in the last 6 months. That took 5 years to adjudicate an LPC and an MFT complaint that initially been appealed. After the initial appeal, I reached out to the Ombudsman for Health and Human Services, and their help was tremendous. And I believe assisted in the adjudication and final ruling of surrendering. The therapist in this case voluntarily surrendered both licenses pending disciplinary action. What I'm worried about with your board is without the ability to appeal, there is no other course of action. You are a self-regulating body. When I reached out to the Ombudsman for the Health and Human Services, they have no oversight over your board. There is no way to get any assistance in the investigative process. And when I went and reviewed your investigators, the average pay is $40,000. That's what your board pays your investigators. So to that end, I'd like to know what the training budget is for the investigators, because there's been a lot of discussion today about high conflict, and I guess the new is highly charged cases. And I need everybody on this call to really understand what's going on. The assumption that both parties have money and are freely engaged in litigation is just wrong. In the majority of these cases, as Peggy Wright mentioned, as Joan Meyer has mentioned, as the research is coming out, there's one party driving litigation. They're paying for it, they're keeping people in court, they're paying for the specialists. I've already spoken to you about the secondary income stream of the evaluators know they write a lopsided report. They are then hired to testify. I'm in a really fortunate position. The University of Texas domestic violence case helped me, clinic helped me. So I'm not bankrupt and I have my children back. That is not an option that is available to most people. So I would like moving forward this concept of high conflict, highly charged, as if both parties are equally at fault. It just simply isn't the case. And at some point, this board needs to start examining the clusters of complaints you have, because the public doesn't have any recourse. There's no way to appeal. And when you allow board members to solicit help publicly and speak on behalf of you, it doesn't look like you're self-regulating at all. It looks like you're protecting each other. So I will follow up in writing. I'd like to know what kind of training is available for your investigators. And finally, could you get some kind of portal or some kind of interactive system where when people have filed complaints, we can go in and see where it is in the process? There's no oversight for us of what is going on except to get a letter of dismissal. I have not received a letter of dismissal, but I know others that have, and there's no recourse. So as you move forward as a self-regulated entity, these are issues that need to be addressed to restore faith in what you do and how you regulate your evaluators. I'll follow up with written questions so we can get what kind of training is available.
Thank you, Ms. Coronado.
Dr. Albritton, did you have public comments you wanted to give?
I certainly do. Thank you, Mr. Spinks, and I'll be quick. My name is Ben Albritton. I'm a licensed psychologist in Dallas. I also have board certification in forensic psychology. I've conducted more than 250 child custody evaluations since my licensure in '86. Also, I'm frequently involved in family therapy, individual therapy, and evaluations related to legal issues, especially family law. I assisted in 107. It was great to hear from lawyers and even a former judge today. I want to sincerely thank the members of the DHAC board for their time, commitment, and curiosity about how to expedite and improve the services we provide to the families in Texas. I believe we share the same goal of making the ample and quality services available. One of my passions for the last 15 years has been to encourage other mental health professionals to become involved in forensic work. This is an effort to help families protect and provide their children. I pled and begged for professionals to enter the field. The number one reservation voiced is always the same: fear of board complaints. While there's an overwhelming need to make sure that our services comply with regulations like 107, on the other hand, limiting the number of available professionals is a serious and chronic problem. We need the board's help to ensure that qualified professionals are not frightened or steered away from helping families. We need more evaluators who are well regulated and are not living in fear of complaints that are frivolous. Even in a big city such as Dallas or Fort Worth or Houston, there's barely beyond a handful of skilled, seasoned professionals that will jump into these complicated and conflictual matters. Every case that we take on, every single case, we make a decision. Is it worth the risk? We're consciously deciding whether to enter a minefield. Right now, I see several neurosurgeons in my practice, and it came to me when I was thinking about this meeting. What we do is kind of like brain surgery, not because we're so smart, but because the field is fraught with difficulties. Neurosurgeons have the highest rate of patients who don't recover and one of the highest rates of complaints and malpractice suits because, just like us, they deal with very difficult, complicated, troubled cases. Many of the complaints that we have are not necessarily because the evaluators are bad, but because you're willing to take the risk. Personally, and I believe I speak for many of my colleagues, we never stop thinking about a case. We think about it when we get up, when we go to bed. Likewise, when we get a complaint, we never stop thinking about that. All of the mental health professionals that have spoken today, most of them I know personally, they confer, consult, and they seek continuing education. I'm really, truly saddened that parties are angry, misunderstood. I wish everyone could be happy. I didn't enter this field to hurt people, but to help people, and especially children. People are hurt, scared, and damaged, and impaired, and that's unfortunate. But we can't let that interfere with providing quality services and seeking the best interests of children. In conclusion, I got a call from a colleague last night who's doing a child custody evaluation. He was scared, with good reason, that one of the parents, when he issued his recommendation, would hurt themselves, hurt the child, or flee the state. This is a kind of dangerous field that we work in, and we have to ask ourselves, do we want more numerous, well-trained professionals who are willing to step up to the plate and face this task? I believe we do, and I believe adopting the current revisions put forward by the Texas Psych Board to the complaint process will allow for more professionals to be available to help the children of Texas. Thank you very much.
Thank you.
Caller, did you have any public comments you would like to make? Okay, none. Caller, did you have any public comments you would like to make? Caller, did you have any public comments you would like to make? Caller, did you have any public comments you would like to make?
No.
Caller, did you have any public comments you would like to make? Caller, did you have any public comments you would like to make?
I do. Can you hear me?
Yes, ma'am.
Excellent. Good morning, everyone. My name is Hannah Falkenberg. I'm a management consultant, and I've known Alyssa Karsagi for over 13 years. She was my babysitter for many years when I was young. I want to thank you all for your dedication and commitment to our public safety and for accepting these comments. I'm here today on behalf of Ms. Karsagi, Ms. Patrick, and Ms. Craig's children because I believe that the safety of a child is worth fighting for. I'm here because I believe that you, as an executive council, have both the authority and desire to do the right thing by holding those who create flawed custody evaluations accountable. I'm calling on you to intervene and hold the TSCEP board accountable for their responsibility to protect the public by revoking Dr. Arredondo's license. Alyssa's children tragically represent just 2 young lives who will be forever altered by a traumatic childhood of physical and emotional abuse as a result of Dr. Kim Arredondo's involvement. Dr. Arredondo produced a biased report with false data that has placed Alyssa's precious boys and many others in danger, trapping them in an endless cycle of domestic abuse. One might try to justify this particular incident as an unintentional mistake on Dr. Arredondo's part, except for the many other cases she has been involved in, all of which have an eerily similar story of domestic abuse. These stories cannot be ignored. You've already heard the story of a boy named Shane who was placed in the custody of his father based on evidence produced in Dr. Arredondo's faulty report. This young boy has pleaded for help to go back to a parent with whom he is safe, and those pleas have been ignored. He has been living with his father, where he says terrible things have happened to him. In Alyssa's case, Dr. Arredondo's license has allowed these children to be placed in the custody of a man who held a gun to his head in front of both Alyssa and her children. Dr. Arredondo is the reason that these young boys are with their father, whose abuse is evident on their little bruised bodies every time Alyssa is allowed to see them. Despite this evidence of continued domestic abuse, Dr. Arredondo's license gives her the ability to make these evaluations that are continually cited as primary evidence, giving courts the power to put these children in danger. As Peggy Wright mentioned earlier, there's an inherent bias in custody evaluations which allows situations like this to happen. I am here because I am a deeply concerned citizen, friend, and wife. If your child was being abused, I'm sure there is nothing between heaven and hell that would stop you from fighting for that child's safety. It is unthinkable that this board would allow child abuse to continue legally when they had the authority to stop it in these cases by revoking Dr. Arredondo's license. I'm here asking you, who have the authority to protect the safety of these children, to intervene and permanently revoke her license. Evaluating a child's long-term safety is a very, very serious issue, and this doctor must be held accountable for doing her job, which she has failed, to protect the most vulnerable among us. Victoria Harvey and many others spoke of the current rules in place for the custody evaluation complaint process. I ask you, if the regulations for custody evaluators are truly sufficient, how is it possible that children continue to be placed legally in abusers' homes as a direct result of these evaluators' reports? This is not justice, and as protectors of the public, we cannot accept this as sufficient. Adrian Tinder highlighted the concerns of the custody evaluator supply, which I agree with. And while this may be true, the solution is not to allow incompetent evaluators the grave authority. And economic issues should never be used to justify injustice, as doing so would promote child abuse and allow these cases to continue. Several custody evaluators have also recommended that these families pursue extra evaluations and the appellate process. But these recommendations ignore the reality that these families often don't have the finances for these expensive escalations, giving them essentially no opportunity for recourse. Victims of abuse should not have to pay thousands of dollars to have the faulty report of an incompetent custody evaluator recognized as such. This is justice with a bias towards those who have the finances to secure justice. In conclusion, Dr. Arredondo has failed her job by failing to protect the most vulnerable among us. It is now up to you as a board to protect them. I ask you, please intervene and rescue these children by holding the board accountable and revoking her license. Thank you so much for your time. I'm sorry for going over.
Thank you.
Caller, do you have any public comments you would like to give? Caller, do you have any public comments you would like to give? Concludes the public comments, Madam Chair.
Okay, thank you. I do have a statement from our Council Chair, Gloria Canseco, that I would like to read to you guys. We have heard quite a number of comments for and against the rules regarding child custody evaluation. And Chair Canseco says this: state agencies such as the council must enforce practice standards for professions under our jurisdiction. There's been a great deal of discussion about child custody evaluators and their role in the family court system. We realize the toll this takes on families and the difficulties presented by disputed outcomes. The council's investigatory resources focus on complaints related uniquely to the enforcement functions. Adopting rules setting forth requirements for professionals are under our jurisdiction, yet where court-ordered evaluations are concerned, we must yield to the judiciary in accordance with due process. In other words, we have no jurisdiction over the courts or the court decisions. As such, we encourage those with custody concerns to direct comments and recommendations to the Texas Judiciary Council. Okay. So we have concluded item number 3 on public comments. And now we are moving on to item number 4, review and approval from the minutes of the prior meeting.
Madam Chair, I'd like to make a motion to approve the minutes as distributed.
Okay, we've got a motion. Is there a second to that?
Second. Madam Chair, I don't mean to interrupt, but there was one correction in those minutes that I thought might need to be made, in that the minutes list Chair Canseco as being on the Strategic Planning Committee, when in fact it was you, Chair Smotherman.
That's right.
Yeah, you were on
Yes.
that. I think that was the only change that I saw that needed to be made.
I amend my motion to accept that change. And this is George Francis speaking.
Thank you, George.
I second the amendment.
Okay. So we have a motion and a second. Is there any other discussion? All in favor?
Aye.
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 Okay. Item number 5 is review and approval of the strategic plan for 2021 through 2025. Mr. Spinks, you want to lay that out for us?
Sure. The strategic plan is something we have to do every even number of year in between legislative sessions. This is the plan that I've put together for us. Really the basic function of a strategic plan is you outline your primary objectives, what your agency does, what you're here for. And we're here to license, enforce rules and regulations, and provide the public with information and other governmental entities information in response to requests. So it's what I've tried to structure or put out in the strategic plan here, lay out our goals, how we'll accomplish those objectives in the next 5 years. Given that we're a brand new agency, it's a little unique doing a strategic plan for an agency that has no contextual back history to draw from. So we're kind of starting from ground zero. I know the plan kind of sets out some very basic things like hire staff. You have to have staff. We have to take those baby steps before we can take the bigger steps. So that's what I've tried to accomplish here. And I'll answer any questions you have.
Madam Chair, first I want to make sure I thank Mr. Spinks for the effort and the work that he put into it. Just an outstanding job, and thank the committee for the feedback that they provided, Mr. Spinks. And I will make a motion to accept the strategic plan as it was distributed to this august body.
I would second the motion.
Thank you, Dr. Fletcher. Thank you, George. Is there any discussion on this? No. I would also just like to say thank you, Mr. Spinks, for your work on this. This took an incredible amount of time and effort. And thank you to those who served on the ad hoc committee to advise on this plan. We thank you for your time as well and the input that you gave into this plan.
And I would let the public know, or I want the public to know, that the members of the Strategic Planning Committee, we read every single comment that you guys submitted in. All, what was it, 1,000?
1,000 comments. Yeah.
We read every one of them.
Yes. We read those. We took those into consideration. I believe I read from Abilene to Amarillo. So it was, and we thank the public for sending in all of those comments.
Yes.
That is an important part of this process. And we are grateful for each one of you for taking time to fill out the survey and for submitting the comments. And we did hear them. And we did consider them as we put this together.
And those
I would
Any
comments.
other
also-
discussion? Go ahead.
Yeah, I just wanted to add that the comments, because I read all 50 billion of them. You said there were 1,000. I think there were 50 billion. We took our time. We went through them, and they were very diverse. There was really good representation. So I just want to thank people for recognizing the need for us to have diversity in terms of the different licensees and other members of the public, because I think that that was really a valuable attribute.
Absolutely. Thank you, Susan. Any other comments on this? All right. Then we'll do the vote. All in favor?
Aye.
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 Any opposed to the strategic plan? Okay. Thank you. Now we will move on to item number 6, review sample status reports on complaint and discuss standardization of those reports. And this was something that was requested in the last meeting by George and I for us to be able to see the reports. And Mr. Spinks has put together a sample report for us. And you guys have had a chance, hopefully, to take a look at that. Any thoughts or comments on the reports?
I will say that y'all are not bound by the history of how any of the agencies have done these things. We are free to make them our own, limited only by what the database can provide us. But I know that the boards have handled this, have received information in different formats. I suspect all the same information will be able to provide everybody with the same information you're used to getting in the past. It might just look a little different. The development of how the reports to the member boards and to the committee, to the council, it may take us a little while to develop that. What I would like is for us to work towards a standardized report that's the same for all the boards and the council. That way it's easier for staff to compile it, and it's easier for the boards to compare how they're doing against some of the other boards within the council, so that it's an apples to apples type comparison. In addition to these reports that y'all are used to getting, you will also begin receiving agency's quarterly performance measures, which that's what the LEDGE and the LBB measure your performance by, are those performance measures. So once we actually start doing something, issuing licenses, processing complaints, you'll begin to see those quarterly performance measures at each meeting. So you'll be getting a little more information maybe than what you have in the past. I don't know, maybe not. Anyway, it's a work.
Mr. Spinks,
what I'm trying to say.
Mr. Spinks, a question for you. With the different formatting and whatnot between these different reports, is it when it spits out the data, does it spit it out in some proprietary thing, or does it spit it out in some sort of like comma separated or Excel format that's easy for you guys to manipulate?
The reports that HHSC received, Tim, you correct me if I'm wrong, they came through a program called RAS, and that is a program that is not coming over with the transfer. So that's why we're going to have to look at doing a different format for the boards that are currently at HHSC. As for how the data comes from our database at TSBEP, I really couldn't tell you, Mr. Blimwitz, because whenever I ask for these reports, Ms. Nowak prepares them. I'm not sure what the raw data looks like.
Got it.
Puts it in. She and the enforcement division put it in a much more polished format for me before I ever see it.
I would just say that when you're trying to get different databases that are spitting out information to you, as long as it's presented in a clear way, I don't really care if the formatting is the same or different. What I would hate to see is a whole lot of staff time dedicated to compiling data to make it look the same. If it comes out in easy enough form for us to figure out, I'm fine with that. I just don't. You guys have enough on your plate to if we're going to be manipulating data, not manipulating, but formatting the data. I don't want you guys spending tons of time on that as long as it's clear.
I've already tasked with Mr. Hyde and Mr. Fernandez, our enforcement division manager, with starting to work on these to see what's a baseline report we could start at. And then I can give that to y'all and y'all can say, well, I don't like this, or I want this changed. We can have a starting point, and then y'all can start telling us what you like and what you don't like in there. So
great.
That'll be for
Thank you.
Would it be helpful for us to have reports that we're already used to seeing, the data that we're already used to seeing sent over to you and to the newly hired staff, so that you can see this is really what we're looking for in these reports? And honestly, the whole point of the report is for us as council members to be sure that we are performing our due responsibility in oversight regarding the things that we're charged to be watching over, and so making sure that we have that data. And I am sure that you guys are going to give that to us. But if it's helpful, then we can have different boards send those over, and you can see these are the things that we're used to looking at.
Yeah, I'll reach out. I'll work with Tim and get the reports that you guys are receiving from Sarah, Alice, and Christina, and then we'll all kind of put our heads together and try to figure out what's the easiest way to present this in kind of a standardized format that doesn't require a lot of staff time and that is easy to understand, to hold us accountable. So.
I think, Chair Smotherman, as you heard in the public comments, at least on 2 occasions, people are interested and want to know what are the median cycle times, how long does it take to process an application, and what are the outliers and how long is that outlier. So I think people are really curious about that, and we know that the legislature is curious about it. So the sooner we get them and the more we get them standardized so that people can compare apples to apples, the better off we are. So thank you for that, yes, Mr. Spinks, and thank you for Mr. Spears for getting that information out to him from the different groups.
We'll get on it. I'll probably leave this agenda item on just as a motivator for us to stay on it. So you'll probably see this again on your August agenda. We'll try and get you something back here. If you don't like it, you can tell us I don't like it. Go back to the drawing board. And we may send it out to the board chairs in the meantime, just to kind of get some kind of a test run to see is this something kind of like what you're looking for. Save a little bit of time, but we're on it.
That sounds good. Thank you. And I know at this point we're asking for a report on data that we don't have because we're not operating with the data yet, Exactly. And so it may be something that, that kind of changes as we begin to operate in the fall. Then it might be something that evolves and changes over time, But thank you guys for working on that. So our next item, unless anyone has anything else on item number 6, are we good to go there? Okay. Next item is item number 7. That's our report from our executive director.
I will try to be brief on the transition plan and everything. I submitted a summary of the big ticket items that we've covered so far. It's about it's a page, a little over a page long. The big items I want to inform you of is we filled all the management level positions for BHEC. All the EDs for the boards have been hired. All the managerial, the executive staff have been hired. You can tell we filled 13 license and permit specialists. I think we've brought over most everybody from HHSC and everybody from TSBP. We've got 5 investigator positions filled. We still have, 10 filled. We still have 5 vacant. We got a few licensing positions that are still vacant. We're probably going to hold off and post the remaining positions in July, at the beginning of July, the end of this month. That way we don't have a long gap between the time we offer the job and when September 1st actually starts, because the more time I have in between there, the more likely they are to jump ship on me and go someplace else. So I want to kind of cut that time down so that I make sure they stay with us. let's see, the IT, we're actually, Ms. Nowak and we need to visit some more with HPC to see if we will need both of those IT positions. We may be able to work a deal with the Health Professions Council to help us out on IT support. I don't know yet for sure. We're pretty far down the process of moving our file server and domain controllers into the state data center, which will help kind of ease the IT load on staff here in the agency. We won't have to manage a lot of that in-house. Currently, HPC does that for us anyway, but that would offload quite a bit for us. The database transition is actually progressing very smoothly. It feels like it on my end anyway. Ms. Nowak might have a different opinion, but between Ms. Nowak and Angie and James, the database managers, everything is actually moving along fairly well there. We haven't hit any major problems. I know Tim and his staff came over to the hobby building, what was it, Tim, last week? Y'all were over here to do UAT testing. They spent pretty much the week here testing the database, making sure all the transactions work. I mean, you have a few hiccups there, here and there, but I don't think there was any major issues they identified in UAT. So we're actually in good shape there. The Facilities Commission, I think I've told y'all this before. We know where we're going to be. The Enforcement Division will be housed where the Architecture Board currently is, here in Tower 2 on the 3rd floor. The rest of the office, the rest of the agency will be over in Tower 3, Floor 9, which is the Public Accountancy Board. They have a big board meeting room that's in-house over there. So that if we ever do get to return to in-person meetings, y'all will have a very nice board meeting room to work in that will just be yours until the state kicks us out and we go to the new building they're building over by the Capitol. But we know where we're going to be for sure. We bought most of the we bought all the computers. Pretty much all the office equipment has been purchased. We're now going to have to start working on furniture. We got, I don't know who's smiling down on us, but somebody is, because we got lucky in that the Public Accountancy Board and the Architecture Board, they're both having to move. And it turns out it costs more to move furniture than it does to buy new furniture. So they're going to leave their furniture there for us, which means we're not going to have to buy new furniture. That is a massive savings for us. So we were like score. That was a good finding there. That's all I have. Oh, the website. I was hoping to have that thing launched yesterday, but I have not had time to work on it anymore this week. I will have it launched by the end of this month for sure. If y'all want to look at it, I can show you what it looks like right now if you'd like to see part of it. Okay. I see a bunch of head nodding.
And also, Mr. Spinks, if you could very briefly just review what the functions will be on the website, because I think especially members of the public want to know if that's the place they can go to about meeting agendas, about issues ahead.
Yep. Okay. Okay, can everybody see where it says history and makeup?
Yes.
Yes.
This is the landing page that I've developed here. Over here on the right is the main menu. It's the key functions that we think everybody will use the most. One of the things that I noticed in the strategic planning comments, and this is where, again, I'm showing you that, folks, that we do read what you tell us, is one of the things I think that people griped about both HHS and TSBEP's website is the main things we go to the website for aren't on that first page. We have to kind of dig for them. And so what we did is we tried to think of what is it most people are going to be coming to BHEC's website for. They're going to be come here to learn what's going on in the agency. So I put an agency news page. That's the very first thing up top. who are the council members? I've got you guys, your bios, your headshots are going to be on here. If there's a council member, if you haven't given me a bio or a headshot and you want one on here, shoot it to me so that I can put it up on the website. We have that. We'll have how to apply for a license. That will probably be a very brief description of what to do and then redirect you to that particular board's website. And if you look up here, we got quick links to the actual individual board websites. Right now, these links just take you to the existing boards. Like if you click on TSBP's, and then if I were to click on that, it would take me directly to TSBP's website. But that will eventually change, and those websites will be hosted on this server as well. Here, this is probably the single most used thing on a website. It's going to be your license renewal and address change. That'll take you directly into the VO system where you do all that online. Discipline and complaints, this will be where we post our disciplinary information, who's been sanctioned for what, maintain that. I don't have anything in it right now. Open records, I've got that one built. The only reason I'm listed in it right now is because I'm the only employee. That'll change. Forms and publications will be the forms that are unique to the executive council. We're going to have each individual board will still maintain its own forms bank for its applications. Everything unique to it we'll build into those particular boards' web pages. The verify license, so that insurance companies and whoever wants to see if you're licensed and if it's still active, they can click on this link and that'll take them to the VO system. I don't have that one done yet. Statutes and rules, we'll create links to the actual statutes on the Secretary of State's webpage. We'll also, what I'm also intending to do is create PDFs for each of the individual boards so that we have council rules and then that board's rules so that people don't have to hunt and they're not having to move back and forth between different chapters in the administrative code. And we'll keep those up to date in a PDF format. The meeting dates and agendas, I've already got it built. I've got the executive council's dates, all its meeting dates listed. And I'll list each board. I'm not sure if I want to stick with this format where you have to scroll through it. I don't know on that one yet. I'll have to kind of play around with it some more and see if I think that's as easy to use or as functional as I was hoping it would be. But employment opportunities, this is where we'll post job openings for the agency. This one right here, the compact for Texans, it's blank right now, but what I want to share with you, what we're doing here is you will see upcoming rules that are being proposed by each of the member boards. There's some language in those rules that talks about that the boards may not engage in any kind of discriminatory act while carrying out their duties. I'm paraphrasing. One of the things we were doing is we were removing that language from each of those board rules because there is a large body of federal case law out there that talks about that. But as an offset, since we were taking it out so that we weren't being duplicative of the federal and other state law on it, I wanted to put something in our compact with Texans, which is basically it's statutorily we're required to have a compact with Texans. And it's basically our promise, our pledge to the citizens of Texas of what we do, how we do it, and that we will do it in a way that is honorable and efficient, if you will.
Oh, forgive me, please, Mr. Spinks, for interrupting you, and forgive my ignorance. I'm not familiar with this term compact with Texans or compact. I don't know that I've seen the word this way. Can you give me a little bit more description or what it means or why it's required or what it is, please?
Sure. It's a statutory requirement in the government code. All state agencies have to have it on their website. So it's not something we can get around. You have to do it, and it has to be approved by both the LBB and the Office of the Governor. Let me see if I can.
Well, what is compact?
It's a promise, if you will, a commitment. It's an agreement between the state of Texas and its citizens, and in very basic terms, it's us promising to the citizenry, here's what we do for you.
Okay.
We're going to do it, and here's the method we're going to do it in. And one of the things I want to make sure that is in that compact is language that guarantees that when we do things, we are not going to engage in any kind of discriminatory behavior. That will be, it's already illegal, but we're making a verbal commitment here in our compact with Texans that we will not engage in that kind of conduct. And I've also included language in it that talks about providing reasonable accommodations to those with disability. So I've included those two things in our compact. And I've sent that off to the governor and the LBB to get their input on it. But once that has been approved by them, I will put it on the website. It'll be in our compact as well.
Okay.
Does that answer your question, Ms. Francis?
It does.
Okay. Let's see. And then I think we've talked in several of the board meetings about FAQs. I haven't got them developed yet. Staff are working on this. Each of the individual boards will have an FAQ page where we can address just the frequently asked questions you encounter, whether it be licensing, complaint enforcement, what have you. We're going to try to break that down between FAQs for the council and then FAQs for each of the individual boards. Then, of course, I have this report fraud in case anybody thinks I'm stealing money. They can report me to the state auditor's office or to the Texas Rangers. It's a way to get in contact with them. We'll have a contact us page. I'm not quite sure how that's going to function yet. It will be more than likely it will be an email-based contact system. I'm not quite sure how I'm going to do that yet. I need to visit with some IT folks a little bit more on that, but that's where we're at on the website.
So, Mr. Spinks, I have to tell you, I really like the functionality and the look of it. I think that most of the key components are there. I would ask you to take two things into consideration, please. One would be that one of the bullets or connect points on the right-hand side would be the status reports. I know that they haven't been built yet and we haven't been receiving information yet, but I do think it's a vital link that people can very quickly go and see where we are in terms of our processing times and other metrics or other data that we're going to build. So I think that would be a very quick point. And the only other thing that I would ask you is that since so many of the people who access this, if you think about the new generation, they will be accessing it via tablets and phones. And so that if you keep it in a scrolling style, then it's much faster and easier to access on your phone when you want to look things up than if you keep it a wide page style, which is primarily meant for a computer screen. So I would just ask that you keep those two things in consideration, please.
Okay. But look,
thank you.
Let me hear, Mr. Francis. Is the way I have it right now? Is it better? Is it suited more for the phone and the tablet?
Yes. Anytime you do scrolling, when you mentioned the comment about you weren't necessarily sure you like the scrolling, the scrolling is definitely much faster and much better on the phone because your phone screen's not nearly as wide. So once you start putting things out width-wise, then it starts getting a lot smaller and you're having to do a lot more manipulations and pinching and pushings. And so, yes, any scrolling is better. Any direct contact links like you have from the front page where it can immediately take you there is also great. So I think those are two great design features that you've worked in. So yes.
Okay. Man, you're earning your pay today.
You know, I've been in quarantine for a while. Lots of time to think.
All right. That's all I have on the update. As far as the transition plan, I need to focus. The only area where I'm probably a little displeased in my performance or where we're at on the transition plan is the website, because I was hoping to have it done by today. But I'm going to kind of shift. I'm going to shift into high gear on that and turn my attention towards that. So, because I've got to get that done before the end of this month. But other than that, we're on track with the transition plan. We're not running into any issues. We haven't bumped into anything yet. So I don't have anything else to report, Madam Chair.
Thank you. And Daryl, thank you for your work on all of this transition plan, not just on the plan itself, but on implementing. Thank you, Ms. Nowak, and thank you, Tim Spear. And I mean, you guys are doing a remarkable job behind the scenes, getting a mass amount of work done in a very tight time. And then we throw on top of that the fact that a lot of you are not able to be in the office, and we're having to be flexible with social distancing and all of that, which we, of course, never could have anticipated when we said, yes, we can make this thing happen. And just massive kudos and congratulations to you and your staff as you're putting all of this together. And I wish I could name each and every one of you to highlight your success in this. And honestly, you're making us as a council look good, but you're doing all the work. So thank you.
So, Madam Chair, I apologize. I have two quick questions, please, and I don't mean to belong the report. Mr. Spinks, you mentioned two things. The first one, that we're going to leave some job openings till the end of the month, so that there wouldn't be such a long time to bridge. Have we transitioned the majority of the staff from the various agencies into this, and the positions that are still opening, if those agency staff members are the right people, are there still openings for them, or is that what we're still looking to do, if they're the right people, the right candidates?
Yeah, we've transitioned almost all of the staff from HHSC and TSBP into BHEX positions. We're now having to look outside of those two, outside of HHSC and outside of TSBP, to fill the remaining positions.
Okay, and that's not a bad thing. Truth be known, there are a lot of good qualified candidates out there, about 28 million. So I think that's not necessarily a bad thing. This is a good time to hire if you have to hire. So that's number one. Number two, the item C under the report from Executive Director about the requesting agency plan for 5% budget cuts. I know that in my line of business, those cuts, they can tell me, okay, we're not going to make cuts right now. Thank you very much, George. You don't need to give us 10 head count or 20 head count. And then 15 days from now, they can say, not only give me 20 head count, but you've got a challenge of $100,000 on top of the 20 head count. Yeah. Is that the same possibility that would occur at the state, that even though they've come back now and said that we don't have to give them the 5%, a month from now, they can come back and say, no, we really do need it because taxes are falling short, or the revenue is falling shorter than what we thought, or we've entered a second period of COVID-19, and so it's even worse than what it was before?
Yes, sir, that is a possibility. I think what you will also see is, even if that possibility doesn't come true, once the LAR instructions come out, in other words, our budget request for the next biennium, I suspect what we're going to see is a reduction in our baseline funding. So in effect, if we escape any kind of a 5% reduction for this biennium, I suspect we're going to be hit with a 5% or more reduction in the coming biennium.
So if there's a possibility that they cut our baseline, are we better off with staffing up sooner rather than later, that lifts our baseline so that we don't take a cut and risk the possibility of losing requisitions that we have but are not staffed?
I don't know that staffing up now would necessarily guard us against having to cut later on, but it's certainly a better position from which to argue than it is to leave those positions vacant on gambling on the fact that we'll be cut. There, you're just kind of cutting your own throat. If my throat's going to get cut, somebody else is going to have to do it after a fight. So I would rather do the hiring now, and then here's the thing. Here's the argument that I'm making. We gave the legislature, the LBB, the numbers it would take to set this agency up and make it run in such a way that we think it will cure all the deficiencies and all the problems that we all had in Sunset. This is what it's going to take to do it. And I don't want to now undercut or negotiate against myself and say, well, I think I could still do the same thing with, a 5% reduction in staff, because I don't think that at all. So
I agree. That's why I'm asking if we're really better off making those hiring decisions now versus waiting, or doing any capital purchases or anything that we need as an organization or agency that's in the budget, doing it sooner rather than later, so that we establish a higher baseline, so that we don't necessarily cut something that we might need, like an investigator later on. That's so.
I agree. And yeah, we're moving forward with that. I'm not planning on leaving any positions vacant because I think that will seriously undercut our operational ability.
Okay. Thank you. Thank you, Madam Chair.
Thank you. Is there anything else, Daryl, on item number 7?
No, ma'am.
Okay. Council members, do you have any other questions for Mr. Spinks?
No.
Outstanding report.
Yeah, thank you. All right, we're at 11:55 and we are about to go into the item regarding rulemaking. We have a few more items left on our agenda. Do you guys want to take a lunch break right now? You want to push through? Is there any kind of a consensus here?
I think rulemaking is going to take quite some time. So maybe 20 minutes lunch break, quick lunch break, and then come back.
Okay, why don't we do this? Why don't we break until 12:30? That'll give us a little bit of time and everyone go get something to eat, get refreshed and be ready to go. Will that work?
Yeah, so reconvene at 12:30?
At 12:30.
All right.
Madam Chair,
Thank
do you
you.
need a motion to, since we're going to reconvene, to pause the meeting now and then come back?
Do we need a motion? Patrick is shaking his head or nodding his head. Yes. Will someone give me a motion, please?
Madam Chair, I make a motion to adjourn the meeting for lunch and to reconvene at 12:30.
Thank you, Mr. Francis. Is there a second?
I'll second it.
Thank you, Dr. Fletcher. All in favor?
Aye.
Aye.
Thank you. And so as a reminder, we need to mute our mics and turn off our cameras.
Yes,
Thank you.
Yeah, because I have to keep this running, or otherwise we won't be able to get back in.
Okay.
Thank you. Sarah Abraham. John Blamowitz.
Present.
Timothy Brown.
Present.
Steve Christopherson.
Present.
Susan Fletcher.
Present.
George Francis.
Refreshingly now present.
Ben Morris.
Present.
Jennifer Smotherman.
I'm here.
Awesome. You do have a quorum, and I will note when Ms. Abram rejoins the meeting.
Thank you, Ms. Fletcher. All right, so we are on item number 8 regarding rulemaking, and we have a number of rule packages before us today. The first one on our agenda is the review of public comments received and changes suggested to the council's proposed rules by the Office of the Governor, the Budget and Policy Division, and the adoption of the council rules, chapters 881 to 885, related to general provisions, applications and licensing, renewals, complaints, enforcement, and fees. In thinking about how to take all of these rules, instead of going rule by rule, Gerald, would it be, or maybe Patrick, either one of you giving us some suggestion, would it be best maybe to take each one of the chapters and then vote on each chapter, take the whole thing as a whole? What would you guys suggest?
I would suggest that we discuss any changes, have any discussion about changes that the council members think need to be made, and discuss the changes that were suggested by the Office of the Governor. And then if we're all in agreement about what those changes are, then you could just adopt the BHEC rules en masse with those changes incorporated.
Okay. Can you give us an update on any recommendations from the governor's office?
Sure.
I'm sorry, Madam Chair. May I make a recommendation, please? As we
Yeah.
go through the recommended changes before we adapt it en masse, is it possible for someone to share their screen, Mr. Spinks, so that we can all simultaneously look at those changes on screen, and that our audience of 47 people can also see those changes and join along with us?
Sure.
That'd be wonderful. That way we always stay on the same page and we're not trying to shuffle through computer notes or hard paper.
Thank you. That's very helpful.
Okay, the first up is where the first set of changes will be is if you recall from the proposed rules that are coming up from the LPC board, one of the changes they want to make is changing the title from LPC intern to LPC associate. That term, LPC intern, only shows up twice in council rules. And we thought it would probably, if we're going to propose that change, it might be best to go ahead and make that change now in the council rule so that our rules match up with what the LPC rules are once they're adopted. Now, candidly, we'll kind of be ahead of the game a little bit. The council rules would be adopted before the LPC rules would be, but I'm going to be willing to bet that most of the LPC community is not opposed to the change from the LPC intern to LPC associate. So I'm not looking for a lot of pushback on that particular change. So the LPC, the only place that shows up is in our definitions, which is 881.2. I don't have it indicated on this form here because this was prepared before we had the LPC rules finalized, so I apologize, but this is where it would change right here. We would just change that literally to say LPC associate. This would be stricken through associate. This would change to associate. And then the only other place it shows up is, yeah, the fees rule. Let's see, why not? The only other place that LPC intern shows up in our rules is in the fee rule, and it's, let's see here, right here. We would be making those two changes, and those are non-substantive changes. So those were not changes, again, those were not changes that were recommended by the governor's office. They are changes that staff are recommending in BHEX rules based upon changes that the LPC board is sending up.
That's an easy change.
Yeah. The next change is in the applications and licensing rules. And here's where we get into the governor's changes. If we look on page 14, we see where the governor's office wanted us to include notwithstanding subsection A. It's a non-substantive change that we didn't see any problem with. Next change is on 28. Here they just had it strike in person, which that makes sense. I mean, given the way we're doing meetings now, it doesn't make sense to make somebody show up in person if we can do it virtually. And then I had listed the actual name of the act in this particular rule, and the governor's office suggested that we change that to occupations code because nobody's going to know where those acts are probably. It's just easier to identify the code that they're in. So again, that's a non-substantive change that I thought was a pretty good idea. And this one, the governor's office suggested simply reordering it so that it matches the order that's in the statute in chapter 53. I had it reversed, so they just suggested the reordering of it. And those are the only changes that the governor's office had on applications and licensing. The only other changes that they suggested were in the complaints rules. You guys stop me if I'm too fast or I've lost you. Oh, on page 8. Here they changed that from we'll make our forms available for free. I'll make it for free. That's a non-substantive change. Here they wanted to make sure that that was clear, that it was the public or individual member of the public. I never did read public to be anything. I always read it to be inclusive of individual members, so that just a non-substantive clarification. They just changed this little verbiage here. This just creates discretion as to whether or not failure to cooperate would serve as grounds for disciplinary. Again, that's a non-substantive change. It's okay.
Can you go back to the previous one and tell me where that was?
I'm sorry, it's on page 20 of the PDF.
What's the rule?
The complaints and enforcements chapter, 884.
Mm-hmm.
And my page numbers are references to the actual PDF page number file, not these page numbers.
It's 884 what?
884.12.
Can we look at C on that too? Because, and I don't know if this is substantive or not, but what if we change the council may solicit input and put shall solicit input of the member board when considering a contested enforcement matter?
I don't think that's going to be, I don't think that would be a substantive change to you.
On
C.
C.
While he's cogitating on that, my only thought on that is when you look at A, the way a complaint disposition will work under the council is, let's say we get a case back from SOA, we've had a contested hearing. It's going to go to the member board. Y'all are going to have to decide. You're going to have to listen to the respondent and the lawyers argue in front of you and beg and plead what the punishment ought to be. So once you decide that, that is then going to come up to the council. The council has no choice but to accept your recommendation as to what the punishment is, unless you're just so far off the rails, you revoke somebody for what should just be an administrative penalty. Unless you've just gone just completely berserk in what you assess, the council has to go with what the member boards suggest. So the reason we have may in that rule is if we've got a recommendation from a member board to the council that has to be followed, what benefit or what do we get out of it by saying, council, you now have to consult again with the member board whose recommendation you have to follow unless it meets one of these limited criteria? It kind of puts us in this cycle. I don't necessarily know that it would be the most efficient way. Can you do it? Yes. I don't think that would be a substantive change, but that's why we have that may in there, is so that we don't run into a scenario where we've gone through SOA, we've got the order before the council from the LPC board that says revoke this guy, and now we have to contact the LPC board again. What are we going to ask them? They've already sent up their recommendation. I'm just not sure what we would do with it at that point from a practice.
Feels redundant. What you're saying?
Yeah.
Okay. All right. Can we look at 881.21D?
Oh, 881. I'm sorry, Steve. Yeah.
881.
Yeah, hang on.
There's just a couple of these I want to look at. I don't want to take anything off track. Certainly, we want to be able to, go forward. But if these are non-substantive, then I want to ask about that now while we get everybody together.
881.21D.
D.
Okay.
The council will respond to a written request. Well, there we go, for adoption of a rule from an interested person in accordance. Is that, I had one about scope of practice being forwarded to the board.
Right. This is what Ms. Freeze had referenced in her public comments, and this is something I did want to address. One of the concerns I think is from the stakeholder base is they don't want the council wading off into something it shouldn't be wading into, i.e. scope of practice, standard of care, CE, schedule of sanctions, none of that stuff. We got to be hands off on that stuff. And I think what they're worried about is unless there's something in the rule that says those types of petitions have to be sent to the member board, I think they're worried about the council maybe overstepping its bounds. I don't have those same concerns because by the operation of law, the statute, our management actions, you guys can't touch those things to begin with. So that's why we didn't get down to that level of in the weeds, that rule, because inherently you have no authority over those things initially. So as a staff, I mean, from a very practical standpoint, and I'm pledging and telling you now, if I get a petition for rulemaking in that says, I want the LPC board to change the number of continuing education hours, I'm not bringing that to y'all. I'm pitching that straight to Steve's board, and they're going to have to deal with that first. And, hold the hearings and do all that fun stuff. That's not even going to come to the council. You're not even going to know about it unless the LPC board sends it up to us with a rule change. So, I mean, from a very functional standpoint, that's the way it will work.
Okay.
Does the shall, I have a question about that. Does the shall limit the council in any way? Is there any reason why we couldn't or wouldn't use shall instead of may in that rule?
Where are you at, Jennifer?
Aren't we on 884? Oh, no, we're not. We're on 881. I'm sorry. I'm on the wrong one.
Well, you're going back to the one we were talking about?
Yeah, but that was already cleared up. I understand that. I need to move. I got lost. I'm sorry.
So are you clear on 881.21D, where if it comes up, it's gonna go to the board?
Are you asking me, Steve?
Well, no, Jennifer. If she was, she understood where we were at on that. So briefly.
Yeah, I understand that. I'm wondering, does it hurt anything to have the language in there? I understand that we're bound to do it by the statute. Does it hurt anything to have the clarifying language in the rule?
No, I don't. Honestly, no, I don't think so. No.
Jennifer, are you asking the legal difference between may and shall, and one that forces you to do an action where one allows you to do an action if you so desire? Is that what
I was, but I was lost, George. I'm found again.
Yeah, we're on the 881.21D. And he was saying that some of this is just the way it's going to be anyway. Rephrase what you were saying, Daryl. That
from practical, I mean, we're bound by the statutes that limit the scope of what the council can do, and petitions for rulemaking that speak to those matters that are reserved exclusively for the member boards. In other words, your scope of practice, your standard of care, your continuing education, that kind of stuff by its very nature can't go to the council. It has to go to the member board because the council has no authority to initiate rulemaking on it. only you guys can do that. I think what maybe the public is worried about is, I don't know, maybe if they say, well, what if staff don't like this thing and they want to kill it, and they send it to the council just to kind of run the clock out? You know, I mean, I guess I could see that kind of a fear. I think I'd probably get fired pretty quick if I did something like that. So, you know, I don't think I don't think that, you know, I'm not worried about that, obviously, but I can see where that fear might be. Short, I guess if you want to make the change, we could. Now the question becomes, is it substantive or not? What, to me, the safest course of action there would be to not do it, put it in your back pocket, repropose it, and add it in there after.
Yeah.
There, would there be a difference? What difference would it make?
It wouldn't substantively, it wouldn't make any difference, because I can't send a rule that belongs to the LPC or psych board. I can't send that to y'all. I have to send it to that board by the way our statutes work.
This is sort of the idea that this council is supposed to be more guardrails and not necessarily actively doing a whole lot. The active rulemaking should be done at the board of which it concerns level, and then we check it or not check it. But we're not starting things here. Is that am I wrong, Daryl?
No, you're correct.
So this would and this would be possible substantive change. I don't want to derail anything. Something to keep an eye on, but the nature of the beast, of the way we're set up, is it's going to go to the boards anyway.
Correct.
Okay.
You know, I think if the concern persists after this meeting, I think what you do is you just propose a change to that rule in the future and go, okay, fine, we're going to just lay this to rest once and for all, so that everybody's, and we'll put some language in there. But is it necessary? No, I don't think it is. But if that's what it takes to make people comfortable.
Well, then take me to, go ahead, Jennifer.
I was just wondering, is it a substantive change to put the language in there now?
It doesn't change the operations of anything. So from that standpoint, you know, I would say no. Patrick, do you lean one way or the other?
I personally like the idea of reproposing it with new, adopting it as is, and then reproposing it with new additions for new comments. Does it affect, are individuals going to be impacted differently by this, or is it going to be more stringent requirements? Possibly. It's hard to, you know, I think it's basically, it depends on the crafting of it, I guess. It's kind of hard to, you know, some of the really simple stuff with name changes, really not. That, I don't know.
So the safe approach is to repropose it so that we don't stumble into a problem where somebody jumps up and says, well, that's a substantive change. Now it's invalid. Now the whole rule is invalidated.
Okay.
Okay.
Are we going to have a list of rules that maybe we'll revisit after sometime in the fall? Are you guys keeping a list of rules that we probably need to look at again?
We are now.
Thank you. So if you'll put that one down as one of them, I think that would help everybody to feel better about this one.
Yeah. And the last one I want to bring up is I doubt that it's substantive, and its design is 882.9A. That's 882.9A, just asking to break out the reports into licensing types. 882.9A. And it's more of a question if it's would be an issue.
That one will be a substantive change.
Would be?
Yes, it will be. Now, I will tell you from a very functional standpoint, based off Mr. Francis's comments, the change he wants to see made to the website, that change to the website is going to resolve the heart of what you're talking about.
Okay.
That will address it. So, from a very functional standpoint, that problem is solved.
Yeah. Okay. As long as it's out there and people can see that, then that helps. Okay.
Yeah.
I don't go down a road we don't have to go, especially if the website will take care of that.
Yeah. Yeah, because what we'll do is, I mean, we'll publish numbers for the council as a whole, but we'll also publish it for each of the individual boards as well. We'll break that down.
Okay. Thank you.
And I think that that's important that we're doing that. I know that that's already in our plan. Daryl and I, we've already talked about that. And I know we talked about that in the reports. And I also think it's really important for our board members, not only our council members to have that, but our board members so that they're doing their due diligence with oversight. And we learned a lot. Let's say we learned a lot coming through Sunset about what we are supposed to know about and what needs to be really transparent. And so as long as we get that done, I think that that's what we need to be doing.
There's an advantage to publishing those on the website for staff as well. I mean, I'll be selfish for a minute. It helps set expectations. And if you've published out there, hey, here's what the average processing, the mean, or whatever, I forget what the statute requires, but whatever that is. When somebody asks, how long you think this is going to take, I can go, well, right here's the data from fiscal year 2020, what it took us. And that I've used that at TSBEP many times because we publish that information on our website and I can just point to it and go, take a look right there. That's how long it takes us to do stuff.
Thank you for the clarification.
Okay, I think that was all. Did I get through?
Madam Chair, would it be appropriate to take these in blocks, and this block would be called the governor's changes, and we vote on each of the blocks so we don't try to remember each thing?
We could do that. At this point, we've just talked about changes to the BHEC rules.
Right.
And so I think and one of those changes was not a governor change. That change, it was the change to the name LPC intern to LPC associate. And so instead of calling it governors, we might just say, do we approve the changes that have been recommended to the BHEC rules?
Okay. Madam Chair, I'd like to make a motion that we accept the recommended changes that have been recorded and discussed in the last 7 minutes on the BHEC rules.
Do we have a second on that?
I'll second it.
Thank you, Dr. Fletcher. Is there any discussion? Any discussion on these changes or on the motion on the floor? Okay, none being heard. All in favor?
Aye.
Aye.
Any opposed? All right.
And I'll start.
So
I was going to say, I'll start working with staff. We'll bring back the revision to that 884.21 at the next council meeting for y'all to propose that change there.
thank you. So the next item on the agenda is the proposed change to the fee chart in 885.1.
Madam Chair, if you don't mind, I have a request for a correction on the first page under fees, application fees for social workers. About 1, 2, 3, 4 down, it lists upgrade from LMSW to LMSW AP or LCSW. The LMSW AP is no longer available. We could strike that, please.
Okay.
Tim Spear is are those, is that I guess that designation, is it still in the database?
It will be, this is Tim Brown, it's going to be still available for those who have the licensure, but no one else has been allowed to go into that category. It will just be, as people no longer are in the category, it will be dropped off.
Gotcha. Okay. Okay. The
Daryl, are you able to put that fee chart up on the screen so that everyone can see what we're looking at?
I am. I'm fixing to.
You're already on it. Thank you.
I'm gonna actually put up the spreadsheet rather than that PDF. Okay. This is the actual spreadsheet of the fee chart rather than the PDF. It's a little bit easier for me to maneuver. The first change, and this is just a mistake on my part, I left out the initial licensure fee in the original fee chart. It's a $90 fee. It's something that's currently being charged, so it's not a new fee, and it just didn't make it in the original fee chart that we adopted. So we need to add that in. The upgrade from the LMFT associate to LMFT, we learned during the UAT testing that some of those upgrades, the applications for that actually take place online. Long story short, what that means is we hadn't accounted for a $4 texas.gov fee. Instead of raising the fees by $4 for everybody, we just said lower the fee by $4 and then we'll assign, it's still, that way it'll still be $90 what people are paying. And we'll just kind of eat that $4 that's going to texas.gov. So that's what that change accomplishes. Just lowers the base fee to $86. The next thing is the LMFT associate extension. It operates as a renewal. We did as such. We actually, it was set at 130. It needs to be set at 135 so that it corresponds with the other renewal fees, which are all 135. And then the last change, we're just moving these $5 figures. They were in the texas.gov fee, moved them over to the base fee, because as it turns out, they're not going to texas.gov. We think they're going into general revenue through HHSC, as we can tell. So that's just a clarification of where that fee goes. No real change there. Those are the changes we're asking for.
Madam Chair, I would make a motion that we accept these fee changes as displayed on the screen.
Okay. Does your motion include the change that Tim Brown brought up?
Yes, it does. Sorry, I should have been more inclusive in that.
Before we vote, may I ask a question of Mr. Spinks, please? And this may be, I'm sorry, I may have missed the reasoning behind this. Could we go down to the reinstatement of license? Can you share with me again the $500 fee for that? And looking at all of our other fees, I'm just wondering why that is at $500.
Why it's higher than it would be if you just applied for the license?
Yeah.
If we don't set it at that, what will happen is if somebody goes delinquent, it would be, if we set it at, it has to be at 500, because if you set it at anything lower than that, it becomes, let me get this right in my head. because of the way late fees work, you want it to be, I think you want it to be, I'm drawing a blank now. Is Jenny on the line? Okay, because she can refresh my memory now. Wow. We set that for a reason that way, because what we didn't want is it to be cheaper to reinstate a license than to pay your late fees. In other words, if somebody were delinquent and they thought, gosh, it'll be cheaper if I just let it lapse and then I reinstate the thing rather than pay the late fees, we really didn't want people kind of gaming the system. That's why we set it that way, so that there was.
So Daryl, the late fee is added into that 500?
Well, it's not really added into it because that's an application fee in and of itself. But we took the late fees into account when setting that fee amount. But we're not really, there's not a late fee rolled into it.
It sounds like you didn't want to create an incentive to skip the late fees and reinstate a license, and
yes, that's what I'm
to where
trying
you
to
had
say.
you had to place it that high to encourage people to pay it on time, and if they're late, just pay the late fee and carry on.
Yes, exactly. Yeah, that's much better.
Y'all hear me?
It's like unintended consequences. If you set your fee schedule weird, people could take advantage of a loophole, and it sounds like you're trying to close the loophole there.
Exactly. Yeah,
That's correct.
I believe Jenny's on the line. Yeah.
That's exactly why we didn't want it to be an incentive for them to not renew and then you have to go through all the rigmarole of reinstating their license. So it's kind of a deterrent.
Okay, thank you. I appreciate the explanation. Thank you.
Sorry I stumbled through that. glad Mr. Belima would save the day there.
Doesn't matter how we get there, just get there.
Okay.
So we have a motion on the floor to accept the changes to the fee chart as they've been proposed both by Mr. Spinks and Mr. Brown. Is there a second?
I second it.
Thank you. Is there any other discussion on the fee chart? All in favor?
Aye.
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 Are there any opposed? Any abstentions? All right, the fee chart passes. So the next item that we have on our agenda is rulemaking 8C, review and proposal of rule changes to the Texas State Board of Examiners of Professional Counseling rules. Daryl, are you bringing those up on the screen?
I am.
I have a question about all of the rules that we're about to review. In public comment, we heard that not everyone was able to see these rules in advance. Do you know what the reason for that was, or are these available for the public to view now?
Yes, they're on TSBP's website, available for download right now. They're under our new developments and requirements. The entire council meeting packet has to be published, actually, because of the way the governor authorizes to do Zoom meetings. One of the contingencies is he said you have to put your meeting packets online so that folks can see what you're doing. So that's what I've been doing. It's available for download on our website under the new developments and requirements, or the important dates page. It'll be on BHEC's website as well once I publish that. I'm glad, because I do want to mention something. I think it's important that the public understand the way we are having to do these rules right now is not a product of our own desire to do them at the board level without publishing and seeking public input at that member board level and then take them up here. The reason we're having to do this now is because we're on a very tight timeline to hit our September 1st transition date. Normally, I would not recommend, I doubt any of the board chairs would ever would ever do this, whatever, propose rules at the board level, then send it up to the council without publishing it on the website or doing town halls, taking public comment, doing anything like that at their level. The only reason we're having to do it this way now, and I want the public to understand, is it's not a product of our desire. We're not trying to sneak anything by anybody. It's just we didn't really have time between the board meetings of the member boards to propose it out for public comment for 30 days and then get it up to the board. We had to get it here to the council. We had to get it to the council, to you guys, let you look at it. Now it will be published in the Texas Register. Well, if you guys vote to propose it, it'll be published in the Texas Register for comment. And those comments, we will gather them up and we will send them back to the member board for them to consider. So I want the public to understand, you're going to get a shot to talk about it in the Texas Register. You're going to get a shot to talk about it at your member board meeting when it comes up. And then you're probably going to get another shot to talk about it at the council when it comes back up for adoption. So you really got 3 more opportunities to comment here. In the future, I expect that you'll have even more than that, because you're probably going to be publishing these rules at the member board level before it even gets to the council to see what folks think at that level. So I want people to understand we're not trying to pull anything over here on you, but we're operating on a very truncated timeline, which means we've got to be moving. And if we don't, it will be a problem after September 1st if we don't get some of these changes made. So that's why we're doing it in this fashion.
Daryl, thank you for clarifying that. I have a question about something that you just said. Will we actually publish the rules in the register before they go up to BHEC, or are you saying that the boards will make those rules public somehow, maybe on our website or in another way, get feedback before then we would send them up to the council in the future?
The latter is what I'm saying. Yeah.
Okay.
You actually publish them in the register. But I expect you to instruct staff to put them on the website for however many days you see fit. Y'all can town hall meetings, do whatever you want to. And then once you're satisfied with the content and quality of the rule, then you'll make the decision to send it on up to the council. Then the council would have to then publish it in the Texas Register for the formal comment. Hopefully by that time, all of the bugs have been worked out. And, we should have, hoping, very little public comment at that point, because it would have all been worked out at your level.
Right. That is good. And that's something I don't want to be lost in translation so I think that's something, if I don't know where to put that, if that needs to be just in the back of our minds or policy or something that really sets that as the way that we do it going forward. I understand we couldn't do it that way now, but after September 1st, that we really make sure that we're able to get that. I know my board engaged in public comment, at the board meeting, right. But to be able to have a period of time where we're soliciting feedback, I think is very important.
Yeah, I mean, it'll be a huge benefit to do it all at the member board level versus having to do it at the council level. Candidly, you guys are going to be the subject matter experts on it. You're going to be more equipped to answer the issues and questions that come up rather than the council. I mean, I don't mean to be offensive, but it's a better fit to do it down there at the member board level than it really is up here at this level. So,
So I have a question just for clarification. Because we're in a transition, I know that some public comments have been made, not just today, but other times, that we have too much on our plate. And I just want to address, I feel like we're building a house, and sometimes people are asking us to put the furniture in before we even have the floor and the walls in. So there's a rollout process that we're in that I think anyone in their organization has experienced. And so we're in a transition. So up until September 1, has it been the individual board's responsibility to provide the information on their website? I know the Texas State Board of Examiners of Psychologists did that, but I don't know if the LPC board and LMFT did that. Because I could appreciate that there might be a perception there's been some deception because it wasn't easy to find right now. And yet I know where it was made available and I know that it was accessible, but I don't know that because of this transition, if that was apparent.
I'll make a better effort then. That would rest squarely on me then if that's the problem. So I'll make a better effort to make sure that doesn't happen again.
So I know we have a short time before September 1. Up until September 1, is it each of the 4 boards their responsibility to provide the information? And then after September 1, BHEC, it will be on the website and it'll be in one central place, but the boards will still do it after September 1.
Right.
Is that an accurate expectation, just so people are aware of what to expect?
Yes, and to some extent, I'll be able to, once we get BHEC's website up and running, that'll kind of take some of the heat and the pressure off of the member boards to do it because we can do it through BHEC's website at that point. That'll be a natural place to go to find it.
Because I think we all know anything new, people have a lot of questions because they don't know what to expect. And I think we're just in a rollout process, not an overwhelmed process, even though there's been some obstacles we wouldn't have anticipated with the pandemic. I do think that it's rolling out the way we expected and there's an order to things. And we're just in a transition until September 1. I just want to make sure the expectations are set. Thank you.
Thank you. Thank you, Dr. Fletcher, for that clarification. So Daryl, you have the LPC rules up here for us to look at. What part of this do we need to go through?
Staff have looked at this. Of course, the LPC board has looked at it and sent it up. The only issue in the rules that I would point out is, let's see. Yeah, is on page 35 of the rules, 681.92. Here, the LPC board has proposed a change to this rule that would allow individuals who are licensed in another jurisdiction for a minimum of 2 years to basically only need to meet an 80% of 3,000 hour requirement needed for full licensure. I think this is a good idea. I like this. I think it's definitely going in the right direction. It's got mobility in mind. It's got licensure portability. That's what the ledge is looking at. That's what the governor's office is looking at. They like this. I think probably what we need to do, though, is I would like to pull it out and send it back to the LPC board just so that we can visit a little bit more to see how that 80%, how that will actually work given the statutory requirement for 3,000 hours. I'm hopeful that we can figure out a way to get us there. What I don't want to do is rush it right now, and then get ourselves into some kind of pickle down the road. But this is a good idea. I don't want anybody to think that I'm saying it's not, because this is a really good idea, and I'm not alone in thinking that. But I think we probably need to work on it just a little bit more. So,
well, we can kick it back to the LPC board. It was kind of a Hail Mary because we know there's statute, but in our efforts to not just follow sunset, but to create reciprocity and to be on the cutting edge of that, it was a way to say, if you've got 2 years of experience, we want you in here. We realize a lot of other people were at a 2,000 hour internship. And so it was we can massage it. We can look at it and bring it back up because I know the spirit of the law is very good. I think we had a lot of support, board wise and certainly with associations. And so I think it's a good move in the right direction for Texas.
It is.
But if you want to get that back and let us massage it, we can sure do that.
That would be my only I don't have any other changes or any other questions or issues with any of the rules. I would just say let's send this back for a little more development and review. The rest of it, I think, is fine.
Okay, Is there any other discussion on the LPC rules on 8C? Do we have a motion to accept the rules minus the change here that has been recommended to go back down to the board?
I'll make that motion. This is Steve Christopherson, and I'll make a motion to accept sending this or taking this to the next level minus the 80% rule, and we'll look at that at our next meeting and see where we can go with that.
This is G4. I'll second that.
Thank you, guys. Any discussion? All in favor?
Aye.
Aye. Are there any opposed? All right. Then we'll move on to 8D, review and proposal of rule changes to the Texas State Board of Examiners of Psychologists rule.
Chair Smotherman, I don't have any changes or really anything to discuss in there. I can bring up a particular rule if you would like.
You do have a rule to bring up, or you don't?
No, ma'am, I do not.
Okay. Does anybody have any recommendations of changes for the psychology board rules? And I'm really looking to our psychology members when I'm asking that question.
I think we're good.
I'm
You're
good. Yep.
All right. Do we have a motion to accept these rules?
I'll move to accept.
I'll second.
Any discussion? All in favor?
Aye.
Aye.
Aye. Any opposed? All right. Then we move on.
I'm sorry, Madam Chair. Would you clarify who made the second on that motion?
Yes, that John, and then it was Tim Brown, I believe.
Right.
That was okay.
Thank you.
Thank you. So we're on item 8E, review and proposal of rule changes to the Texas State Board of Social Work Examiners rules. Are there any changes in this package we need to be looking at?
No, ma'am. Staff haven't identified anything. It's looks like it's good to go.
Tim, Ben, you guys have anything to suggest here?
I'm good.
Everything looks good from our standpoint for the social work board.
Okay. Do we have a motion to approve these rules?
I'll make a motion, Steve Christopherson, to approve.
Second, G4.
Thank you, guys. Any discussion? All in favor?
Aye.
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 Any opposed? Okay. Moving on to 8F, review and proposal of rule changes to the Texas State Board of Examiners of Marriage and Family Therapist rules.
Madam Chair, I've only got three issues, two of which are minor, non-consequential, really. Let me pull it up here for you.
Okay.
Okay, on page 15, looking at 15 here, under this section here, the subsection C, The only thing I wanted to point out to the board was the LMFT board has this provision in their rules. It's basically repetitive of existing council rule 882.23. We had some discussion at the LMFT board level about, I had recommended that it be removed from the rules, but the board felt like it needed to stay in there. I just wanted to point that out to the council. Generally, it's not a good idea to have, duplicate provisions of a rule in your rules. Duplicate provisions kind of scattered throughout different locations in the rules. I just bring that to your attention in case you want to make any changes, because that particular rule is not one that, it's something that you can change if you want to, but if you don't want to, you can just leave it there. The other issue on this page is that subsection D. I don't think any action on our part is necessary. The only reason I bring this to your attention is this will be the only rule that I can think of that we're going to be submitting to the Regulatory Compliance Division at the governor's office for an antitrust type review. But I'm not expecting any problems with that. The only reason I point that out is because you're the council and you're tasked with also anti-competitive review. So we visited at the LMFT board meeting with Chair Smotherman and Ms. Fassholes, who's the ED for that board, and they assuaged all my concerns. So I don't really have any issue with it unless you guys wanted to talk about it. But are there any concerns or questions about those two provisions?
Jennifer, this is Tim Brown with the Social Work Board. Could you tell me the LMFT board's consideration on this C? Is there a particular reason it was felt necessary
Yes.
to keep it in?
Yes, thank you for asking that. On C, the concern there is that we wanted it to be very clear when people are doing teletherapy that in order to do teletherapy in Texas, you must be licensed by Texas. So one of the main questions that comes up whenever anyone is engaging in teletherapy across state lines or across international lines, do I have to have a license in your state in order to be able to practice there? And you might be surprised that in some states, the answer to that is no, you don't have to have a license to be able to practice here. In most states, the answer is yes, but we wanted that to be crystal clear. I also want to point out that piece in the occupations code, the statute, is not likely going to change. That's part of our Practice Act, and it's probably not ever going to change. So I understand that we want to be careful about having duplicates, because if one changes, then we have to make sure that the rules change accordingly. If that were to change in the occupations code, we're going to have to change a lot of rules.
Thank you.
You're welcome.
Madam Chair, I will make a motion to accept the rule changes as stated for the marriage and family therapist rules.
Okay, we've got a motion to accept the MFT rules with as stated.
I thought Mr. Spinks said there were a couple others he wanted to look at.
Yeah,
There's another one in question right now. Do we need to second it, or how do we need to go here since there's a motion on the floor?
I'll pull my motion, Madam Chair.
Okay, thank you, Mr. Francis.
The only other question I had was here on page, we're looking at 28 of the file. The LMFT board has identified what we're looking at here. These are the list of criminal convictions or your criminal history that when an applicant comes in and they have one of these on their record, it kind of sets off an alarm bell for staff. And staff to now look at that individual and see how long ago did it happen. What was the context it happened? Have you reformed your life? Basically, the list, my concern is that the list that we currently have in the LMFT rules, it has these 4 offenses that are highlighted here. And when I look at Chapter 53 of the Occupations Code, something that the legislature has told us is they only want us really looking at offenses that are directly related to the practice of the licensed profession. And I guess when I was reviewing this, what I was struggling with is I can't see where manufacture of a controlled substance, the theft over the 15, those 4 items are directly related to the practice of marriage and family therapy. And so because of that, I've got concern about whether or not they should be in the list. And so I'm presenting this to y'all for discussion, because these are items that shouldn't be in the list. We probably need to send them back for further development, further review by the LMFT board. We can't just strike them out and play with this, play with this list ourselves. That's not within our power to do.
So hearing the conversation from the LMFT board and seeing that these were sent up, I know that there was a strong feeling and there was a lot of discussion around this and how they relate. And basically speaks to the character of the individual who's providing the level of services. And it speaks to their ability to provide good judgment in that consultation. And so, and I can go either way. If this board, this body decides that they want to send them back, I'm good with that. But I will tell you that it's my recommendation that they do stay in. I would want to know, as a concerned citizen of the state of Texas, whether the person that I'm speaking with has engaged in these activities or has been convicted of these activities. It would mean something to me. So that would be just my quick comments on this.
Mr. Spinks, I have a question, and you may have already said it. I want to get some clarification. The reason your reasoning on this, is this more of a directive from the legislature, or did you say it's already in the law that we need to not be excluding people if it doesn't pertain directly to the job that they're trying to do? I obviously can understand why somebody doing improper photography or injury to a child or organized crime, how those should not be, we shouldn't have them practicing. But theft, doesn't necessarily pertain to delivering psychological services. I share the concern of it does speak to somebody's character if they're engaging in these things. However, we should believe in the ability for people to rehabilitate their lives. So again, back to the question, is the concern a legal one or more of a directive of the legislature one?
It's a legal question that I have. My concern is I don't know that I'm comfortable saying that we have the legal authority to include those particular offenses in the list, because the legislature through Chapter 53 has been very clear that they want people to have an opportunity, a second chance in life, if you will. That if what we're talking about here is criminal history, not conduct you're currently engaged in.
Right.
If you're an arsonist, that's, you get convicted of that.
Right.
You're going to lose your license when you go to prison. But what we're talking about here is stuff that's happened in the past and you come in. The legislature has, as a matter of public policy, wants people to be able to have gainful employment. And as a way to achieve that, what they've done is they've set up this 5-pronged test in Chapter 53. And they've said, agencies, you don't get to deny people licenses if their criminal history is, for lack of better words, unrelated to the profession for which they're applying. And I can't make a connection in my mind between arson, manufacture, those four things. I can't make a connection in my mind between those offenses and the practice of marriage and family therapy. And because I can't do that, it's my suggestion that those 4 offenses should not be on this list. I'm not saying they're not bad things. I'm just saying that when I look at Chapter 53, the legislature and Governor Abbott, who signed it, have told us you don't get to consider things that aren't related to the practice of whatever your regulated profession is.
Under the law, not just by a memo or something else. Under the law, we have to connect it.
And the legislature went one step further. they added a little phrase that they rarely use in statute, and they said this chapter is to be liberally construed. Liberal and the state of Texas don't go together very often. So when they put it in statute, that kind of that particular phraseology doesn't show up a lot in statutory law, but it's here.
This is Tim Brown, and I appreciate Chief Ford's position and John's position and your position, Daryl. But if we take that law that you're quoting, well, if you murder somebody but you don't murder your client or someone that you're seeing, then you should take that off. And with the same rationale, if you don't rape a client, then you should take that off because that wasn't involved in the process of you providing services. And I'm not trying to be argumentative here, but I think if we take that so liberally, we're going to be down to almost no accountability. I mean, do we say, unless you're showing child pornography to your client in your office that you're seeing, then you can't count that against the individual if they just did it on their own time, not at work. I think we need to have a little bit more discretion as discipline experts or to consider these things. And again, I'm not trying to be argumentative here. I'm just saying that explanation in this section being quoted is a little bit of a slippery slope for me.
I guess here's my question. With like theft over $1,500, through college, I worked in loss prevention, and I routinely busted people for theft over $1,500. And depending on the jurisdiction we were in, they may not have ever seen jail time, but it did go on their record. I hope for redemption for those people that they could figure out how to do something good with their life. And you see that people get mixed up in different things or get run with the wrong crowd and get roped into a charge. You don't get roped into a murder charge, and you don't get roped into a child porn charge, and you don't, to the examples that were previously given. I get that, and I wouldn't support allowing those people to practice in the mental health profession, but manufacture of a controlled substance, theft over $1,500, burglary of habitation, and arson, I'm kind of with Daryl. I have a hard time connecting those to the practice of mental health if it's something in their history that maybe they've redeemed themselves, hopefully, if they've done their time. I think this is unlikely to come up very often, but it's more of a legal thing. How do we stand on it? And so far, I've not heard a case for why those four should be connected.
Mr. Spinks, can you go back up the page where they're listed, please? And I guess that I would come along with Mr. Brown's side on this and argue that if you look at kidnapping today is an economic crime where people do it for financial reasons to gain money. And so in my world, if you're going to make this argument, kidnapping should not be on the other side. Kidnapping should be removed because it has nothing to do with practicing therapy. I mean, it was about the money of the situation. When I look at some of these, arson to me is kind of a mental crime. I mean, people burn things who like to see things burn. There's something mental. And I can't speak to that. I'm clearly not a clinician. I clearly don't have the technical or educational background, but that would just be my gut feel. And so, but the theft, it's theft over $1,500. That's an economic crime. I could go either way on that. Manufacturing of controlled substance, go either way on that. That's either economic or, I mean, it's just a slippery slope. How do you make the line and how do you make the decision? I guess where I'm following is that, yes, there's rehab, and if it's past 5 years, then you're good. But all this is saying is within the last 5 years. And so I don't know that the 5-year test is, you want to make sure that they truly are rehabilitated. And if it hasn't happened, fine, let them practice. If it has happened, then you have to question why it's happened again or why it's happened so recently. That's kind of my position of it. But otherwise, all of these and the ones on the other list, like kidnapping, definitely, kidnapping's not like it used to be. Kidnapping is a lot of times economics. I had a director that's been kidnapped 3 times so far in the last 2 years. So.
Wow.
I think it goes back to what a difference a day makes too, because if they do the last 5 years, then it rolls over into 6 years, 5 years and a day, and now you're in 6 years. Did something change in that? So I'm hearing Mr. Spink's concerns that we're raising red flags kind of against what the governor had stated pretty emphatically. Like, if people pay their restitution, do what they have to do, we want to offer avenues for employment. And I want to echo, that sentiment, because I remember seeing that directive. So just keeping in mind that what a difference a day makes, but that's what you have in those last 5 years, then you're considering in 6 years that things would be okay. So I think we need to think in terms of where we're headed with this.
You bring up an interesting point there, Stephen. That is the question of rehabilitation or restitution. And I don't think that is considered at all in these rules. We set a standard there because the boards, and Daryl, you please correct me if I'm wrong, but we set a standard there because the boards are charged to set a minimum standard. Actually, twice in our statute, it says that we can't license people with felonies, and I understand that Chapter 53 is going to override that. But I'm curious about being able to somehow look into the rehabilitative status of the person that's committed whatever crime may be there. I will tell you this, and I understand if these rules need to go back down to the MFT board. It is my public members who have the highest level of concern about these rules. All 4 of my public members have addressed a high level of concern about these, and I don't know that the just saying, well, you have to show how they relate, and we don't think these relate. I don't think that that's going to change their level of concern, because they do think that they relate, and so I'm curious if from the council, do we need to have something in here that speaks to rehabilitation? And B, do we need to give some other directive or perspective to the board as they're reviewing this section? I don't know. I will tell you, we went around in circles for about an hour and a half on this.
It sounds like the fact is that none of us are in favor of letting a whole lot of people into the industry that have these things on their history. It feels like unless we can make a direct case for why these things would impede somebody in the practice, if we can't make that case, it's just a legal argument. And the only one that I can really stretch to is like burglary of a habitation. If somebody has a history of breaking into people's houses, the idea that the practitioner is going to have all the personal information of the patient, and maybe they have something valuable there, maybe they could do that. I'm really stretching there. But in terms of manufacture of a controlled substance, theft over 1,500, and arson, I don't see how those have any bearing on somebody able to give counseling services.
John, I'm curious.
And that's a stretch.
How would you make the argument for kidnapping?
Why
does kidnapping be on the list?
I mean, you think about you're alone with somebody, and I don't think you said something earlier about being economic. I don't think it's entirely economic. I mean, all these Amber Alerts that come up on my phone aren't necessarily economic. So I think that's a big stability thing for if somebody's kidnapped somebody. No, you're not going to give therapy in a closed environment.
I mean, I would argue that if it's an Amber Alert, a lot of those are more parenting issues, and one parent believes they should have the child over the other parent. And
but is that not kidnapping?
No, that is a form of kidnapping, but I would not say just because they believe that about their child doesn't mean that they don't have moral standards and values in other categories that would not allow them to give therapy to somebody.
I definitely would not want a kidnapper giving therapy to my child.
No, and I'm talking specifically about those, in that case, Example, the Amber Alert, where it's about somebody's child. I mean, people feel strongly about their children. They do crazy things over their children. But that doesn't necessarily mean that in all other categories, they're not a good person. They did what they believe was right for the protection of their child. We heard that earlier today, as a matter of fact, where people were discussing about, different views and opinions of what's happening, how the child should be in whose custody. So, but they're just all so, you can go and argue either way.
So what I'm hearing is that your board spent about an hour and a half on this, correct?
Correct.
Yes.
Looking at all that, I can see we could do the same thing. I have a question because I am looking at it as a mental health issue and I'm listening to what everybody's saying. I see that as, no matter what it is, people who think the rules don't apply to them, rather than, is it worse to have an Amber Alert or a director, abducted? I think we all have our concerns about someone who has demonstrated in a pretty dramatic way that they believe the rules don't apply to them. So, Daryl, what do we do with all this conversation since we're talking about at the BHEC level?
I'm sitting here listening to you, and I guess I approach it as a lawyer. And when I look at the statute, I hear y'all talk about rehabilitation, and I guess I keep going back to the statute. And the statute sets out those 5 criteria. Before you can list an offense as being directly related to the practice of marriage and family therapy, you've got to show where in those 5 criteria, you got to show how it's directly related by those 5 criteria. We talked about rehabilitation, but the legislature didn't include that. And, I don't mean to sound harsh here, but we don't get to make up new criteria. That's what the legislature has given us. That's what Governor Abbott signed, and that's what we have to follow is Chapter 53. And I can't make that leap for those offenses in my mind to being directly related. When I look at those, you don't need a license to practice marriage and family therapy to really do anything to commit arson. Your marriage and family therapy license isn't going to benefit you or aid you in the commission of any of those particular offenses. I can see how it might in kidnapping, because you're there. And the thing about y'all, the nature of y'all's profession is it's a closed relationship, confidential. You have almost manipulative ability over people at times, and you can only bring that to bear on somebody to make it easier to kind of gain control or manipulate them into maybe going someplace or going with you where otherwise they would not. So I can see how kidnapping would tie in, but I can't see how arson and manufacturing and theft over 1,500, I forget, burglary of a hab. You're not going to use your license or your skills as a marriage and family therapist when you're burning down a house or when you're breaking into a house. And so as a result of that, I just don't think you can include that in that list.
So let me try one different approach here, please, which is, and I think this is a different type of slippery slope, and one that we have to consider, is that this came from a member board. That member board had an attorney sitting in on the conversations. That member board made the decision to pass this and send it up with that attorney sitting there. And so, which says that there are different sides to it. It can be argued either way. And so where do you put the weight of it? Do you put that weight on the member board with their attorney and what they sent up? Or do you put it on this council? That's a slippery slope that we've talked about early on in the setup of this organization. And I just want to make sure that we're very careful in our consideration and our deliberation of that also.
I think that's a good question. I think that we have to rely on our attorney's advice and our legal mind's advice when we're making a decision. And I think that it's pretty clear that this isn't a memo that we got from the governor. This is the legislature through the force of law and signed by the governor, that we have to make that case for how somebody could use a marriage and family therapist license to either go manufacture drugs, arson, break into a house, or steal.
And that was considered.
I don't know. I've still heard no strong case for why somebody would use a license to do any of those 4 things.
No, what I'm saying, John, is that that was considered, the conversation was had with the attorney, with the law in regard. So my point is that how do you weigh one body with their attorney and then weigh the other body, right? This is what we were talking about early on. You have a member body that has brought something up, that sent something up that was voted on and agreed upon in front of council. So the law was taken into consideration, what the governor sent down, versus this organization. And we're looking at it and we're saying, maybe that member board didn't get it right, send it back to them and let them redo it. And as Jennifer was saying before, there was enough support to come up. I don't know how anything's going to change from what that member board felt. That's all I'm asking us to look at and consider, because I'm sure this will not be the first time that this happens. And so truly, we're setting a precedent here. This is the first time that we're making this type of decision. And so I'm just really curious of how this plays out. That's all.
I'm curious as well. I guess I'd love for somebody to explain to me on how these 4 items, though. I know that they considered it, and I know what their decision was. I'm still not clear on how somebody would use a marriage and family therapist license in the act of any of these four things. I definitely see it on the rest of them. Definitely see it. I don't see it on these 4. And again, I could be persuaded if somebody could make that case. I'm struggling with it.
Mr. Spink, at this point, if we approve these still go up to the governor's office for review, don't they?
Yes, they would have to go through the budget policy division. It puts me in a tight spot if the council approves it, because you got to have legal counsel at this level sign off on it as saying it's within your legal authority to propose and adopt this rule. And I mean, just candidly, folks, I don't think you have it. I really don't think you have the legal authority to adopt these 4.
So Mr. Spinks, are you speaking from an attorney's perspective or the executive director's perspective? And do we have the attorney to also side on that same, does the attorney agree with that? Because I've yet to hear from our board attorney. And so I'm kind of curious along how you're speaking versus what the board attorney is speaking.
I mean, I don't disagree with what Mr. Spinks is saying, and I think Mr. Blenwitz put it very well in that he's said he's looking at those 4 highlighted offenses and looking at section 53.002 that has the 5 elements. It really lays out, you need to look for the correlation, you need to look for the relationship. And I don't, I have a really hard time seeing the connection. I could be persuaded otherwise, but I've yet to make that connection myself. So it's hard for me to say that the statute says the agency shall consider all 5 of these and it has to meet those 5 elements. I have a hard time seeing how it does meet those elements. And going back, I know we went back and forth with this on the previous meeting, but I don't know we ever got into the weeds of how those particular fit those 5 elements in the statute. I know that the board kind of, my personal opinion is I think the LMFT board kind of reached an impasse and just decided this was the compromise that was reached at that board level, and they sent it up. I can't speak for Jeff Bullock. I know he was part of that meeting, but I personally don't remember him commenting on whether or not these were legal or not legal. So I don't know that. I know it was moved forward, but honestly, the analysis for whether or not it's published into the register is from the council's level and not necessarily from the board level. So I don't know if he offered that opinion is what I'm trying to say.
I didn't. Go ahead, Patrick. I'm sorry.
I was gonna say we could certainly ask him, but I know that I personally don't remember him having a specific opinion one way or the other. I don't remember him.
So
broke up. I'm sorry, the last part.
Say that again, Patrick.
Oh, I just don't remember Jeff Bullock weighing in one way or the other as to the legality of whether or not this meets Chapter 53 or not.
So to answer the questions that are here, or to maybe weigh in on this, one thing is, I don't remember, and maybe I got lost in this, and so this would be maybe a different angle to look at. I don't remember the angle of how does holding this license enable a person to commit the crime in terms of tying the crime to the license. I don't think I heard it from that angle at the board level. And so taking that back down to the board and looking at it from that angle might produce something different. George, you could weigh in there. I will tell you that the board members, particularly the public members, believe that these acts would require a mental state of the offender who's willing to ignore injury to the victims while benefiting the offender. And they are therefore concerned that this person could be harmful to their clients if they're able to do that, act in a way that's going to hurt someone else in the public, that they could be. And so if you want to know how do they tie that in, that's really the bottom line, is that they felt like the mental state of someone who is going to commit those acts is called into question, and there is a potential for public harm if someone has a mental state like that. I also think that it's important, and again, this may need to go back down to the board to have this discussion. The backdrop is this: our statute until very recently still said that we could only license people of good moral character. That just got taken out in the last session. It also our statute addresses twice that we cannot license people who have been convicted of a felony or a crime of moral turpitude. And the way that has been interpreted legally for our board up until this point is different from the interpretation that I'm hearing today. And so I think it might help the board if we were able to seek some kind of answer as to which legal standard applies, because really George, you asked about the legal counsel that we've gotten on this specific issue related to Chapter 53. While Mr. Bullock did not weigh in at the board meeting, the counsel that we've had for at least 10 years has been different than the counsel that we're receiving now. And I am absolutely not saying that one is better and one is right, one is wrong. I don't know, but I'm explaining. Yeah, I'm explaining the backdrop of the decision and maybe how this could be something that is hard to wrestle with.
I mean, I just think about some of the comments in regards to, would you knowingly send a citizen of the state of Texas to a person who has committed this offense in the last year, 2 years, 3 years, 4 years? Because basically that's what you're saying. If they committed this offense and they're no longer on that list, and they did it as recently as 60 days ago, they can still be your therapist. They can still practice with you. And would you knowingly do that to somebody you know in the state of Texas? Our charge is to protect the citizens of the state. And in good conscience, I would not knowingly send that somebody to them in the last 60 days that have been convicted of that. It wouldn't happen. And so we can discuss any which way to Sunday, but it's just not protecting the citizens of the state of Texas, bottom line for me. So I know where I would lean towards this.
You are saying that if they've done 5 years, then in that 6th year, they're okay.
I am, because I mean, I do believe that people change. I do believe who you are 60 days ago is a great difference than who you are 6 years ago. So yes, for me, I do believe in the redemptive skills and that people do change. I do believe in redemption. So
I think I would make the suggestion to, and this is a suggestion, I don't want to throw a monkey wrench in, but to take it to the member board, look at it on these timelines. Because I wouldn't mind whatever you do with a timeline, but timeline, and I don't know if these were put down before or after the governor and legislature said this about, licensing people that have been rehabilitated. So you may want to have that discussion. These very same rules may come back up to BHEC, but I think it's it would be wise to at least give y'all a chance to look at that with your council and then come up with some reasons. Great. And if you want to be hard and fast with the 5 years or 6 years, whatever you want to do, then we look at it. But at this point, I just think it could use some more discussion along with the backdrop of what the governor's directive was.
I'm comfortable with that. And so
go ahead.
I was just going to say, I'm comfortable with that. I mean, as a member of that member board, I've heard the different discussion points, and I think there's some validity to some of them, not to all of them, but there's enough to probably go back and take it to the board and suggest that we have another conversation around it and see what the board wants to do.
Brass tacks, Daryl, we've got to pass rules. What does that do by not passing this and sending it down? Or is this something we need to consider passing today, either amended or not, to keep the ball rolling forward and then look at changing it later? Does my question make sense?
Yeah, you can't amend it because you don't have authority to do that. Only the LMFT board can do that. Your only option is to send it back and
Move all the other rules, but not that one, right?
yeah, is it in a policy? Is it currently in a policy?
That chart is in a policy, right?
Okay, so they've got a policy right now. They don't have a rule. The policy would just continue on, would remain in place. So
Point is that we can't really, if it doesn't sound like you can sign off on this, our only options are either to pass it against your being able to sign off on it or send it back. Am I getting that right?
Yes, sir.
All right.
Well, I want to make sure I understand. Daryl, I thought that we could pass the rule. We can take this one out because that's what we've done with other proposed changes, not take this change, but accept everything else, which would allow the rules to move forward.
Correct. That's correct.
Okay, I just want to make sure that I didn't misunderstand. So then, Jennifer, based on that, I would make a motion that we accept the rules as submitted by the marriage and family therapist, with the exception of those rules that related to the criminal conviction, and those get sent back down to the member board.
Okay, thank you, George. Do we have a second on that?
I second that motion. Sarah Abraham.
Thank you. Thank you, Sarah. Is there any other discussion on this?
Can we just be real clear about what we're voting on and what happens by virtue of this vote? I don't know if Daryl, if you want to state that for us again to be real clear on what we're voting on.
All the LMFT rules except for 801.206, the rule you see here. All of the rules will be proposed or accepted for proposal by the council. This rule will be sent back to the LMFT board for further consideration.
Thank you.
Thank you. And I want to clarify on 801.206, that's new language in our rules. Like Daryl and Patrick just mentioned, right now we have that in policy and this language isn't in a current rule right now. Right. So that'll be something that we'll go and look at again in the future. So we have a motion and a second.
I have a question, please.
Yes.
Question, please. This is Morris. So we are not voting on the provision about the 5 felonies. We're not able to vote those in right now.
That's correct. So the motion is to accept all of the proposed MFT rules except this section on criminal conviction. And the section on criminal conviction will go back down to the MFT board to look at further.
You still with us, Mr. Morris?
Yes.
Okay.
Okay. Do we have any other discussion or questions here? Okay. All in favor?
Aye.
Aye.
Aye. All opposed?
Aye.
Who opposed it?
Morris.
Madam Chair, may I do a roll call vote?
Yes, ma'am.
Councilmember Sarah Abraham,
Yes.
I'm sorry, would you indicate for or against?
For.
Councilmember John Blamowitz,
Aye. 4.
Councilmember Tim Brown,
4.
Councilmember Steve Christopherson,
4.
Councilmember Dr. Susan Fletcher,
4.
Councilmember George Francis,
4.
Councilmember Jennifer Smotherman,
4.
Councilmember Ben Morris,
Against.
your motion passes.
Thank you.
Thank you.
And thank you guys for taking time to really discuss that. This is one of those issues that was one of the big questions going into BHAC. How are we going to handle things when the council doesn't necessarily agree with the member board? And so we're kind of finding our way as we navigate through this right now. So thank you for taking time for that discussion.
I'm excited we had our first example. I mean, you got to start somewhere. And so this was as good a place as any to see how it would work out. So I'm very positive for that. So thank you, everybody.
Wait, did we just have our first fight? Is that what you're saying?
We did.
A friendly disagreement. A friendly disagreement.
Well, I appreciate the opportunity of the differences. I really do.
Only
And I
is not
appreciate
Yes, thank you. So we have finished item number 8 and all of the rules, and we're now on to item number 9, which is to review methodology for calculating fees and a discussion regarding the establishment of an ad hoc committee to study possible changes to council fees. So let's take those really in 2 parts. Daryl, why don't you talk to us a little bit about that methodology?
Okay. I had sent you guys an email that kind of laid it out. In all honesty, Mr. Motherman, I can't say it any better than what I said it in the email, so I don't want to just kind of repeat myself here. If you guys have any questions about how I did it, I think Ms. Black is on here with me, so we'll try to answer any questions.
For the sake of those who did not read your email, who might be listening in, would you be willing to fill them in?
Sure. Okay. We basically started out with the premise of, okay, let's start where everybody is right now at their fee amounts. Because what we didn't have time for and want to do is completely reinvent the wheel. We just don't have time for that. So we started with, where is everybody right now? And we looked at what are our biggest fee generators. And obviously that's your renewal fees, your application fees. And so we went through and we basically added $20 to all the application fees. We standardized the application fee amounts for supervisory status. We set the renewal fee for the supervisory status at $50. We increased all renewal fees that were below this amount to $135, so that's kind of the minimum renewal fee. We missed that LMFT associate extender fee, but we've corrected that here today. The one exception was the LMSW AP LCSW renewal fee. It actually went up to $155 because we wanted to keep that same differential that exists between that renewal fee and I guess it's the the regular LMSW renewal fee right now. We wanted to keep that same differential, so it actually went up to $155. And then, of course, we standardized all the miscellaneous fees. The late fees are governed by statute, so that's out of any of our hands. That's just set by statute. In a nutshell, that's it. That's what we did to come up with the fee schedule that's been adopted. Nothing fancy. We had to hit the target that was set out in the the contingency rider. I'm sorry, my brain's starting to turn to mush. But we had to set the amount that's set out in the contingency rider, and that's that's the formula we use to get there.
Mr. Spinks, two questions, please. One, the amount, the fee that we missed that didn't make it the first time, was that fee in the spreadsheet? Once we added that fee back in, did it determine or change the amount that we needed to spread that adder across the other organizations?
We actually factored that in already. It just literally did not make it into the rules proposal that went out. But
okay, so it was in the
we were
spreadsheet.
relying on it.
It was in the spreadsheet. It just wasn't in the documentation that we received.
Correct.
So it was already accounted for. That didn't make a whit of a difference in the numbers.
Right. Exactly.
Okay. So that was question number one. My second thing is really part of the second part of the of number 9 on the agenda, which is that ad hoc committee. I know that we had a time frame that we had to do to get that in, but based on the commentary and the public comments that we've had previously, a couple meetings ago about people trying to understand why fees were raised or increased or why they decreased or whatever the fee did, I would like to be on that ad hoc committee so that we can look at recommendations for the next time. I know that realistically, I don't want to take up a whole lot of people's time today on it because there's nothing we can do about it. It is what it is right now. But let's get together that committee so that we can move forward and possibly do things in the future about it. That would be my recommendation.
And kind of what I had envisioned on that ad hoc committee is that being kind of a council member led type of endeavor. Those of you that choose to serve on it, and then it's y'all's call, but kind of what I had envisioned was asking the various state associations and then maybe even an at-large member, somebody who's not a member of the state associations from each of the professions to speak on that, so that you kind of get a broad swath of people that are impacted by the fees. That's up to y'all, but that's my 2 cents on the committee structure.
Okay. I would like to serve on that too.
And this is Tim Brown. I'll volunteer as well.
Thank you, Mr. Brown.
And what's a quorum? Is a fourth too many?
No, you can have.
You can be on it.
Yeah.
Okay, I'll volunteer to be on that as well.
Good job.
Jennifer, did you say you wanted to be on it?
I did.
Okay.
I like the thought of you being on it, John, because if those are your instruments, music is the second language to mathematics. And so that you're going to have lots of.
That's right. That's right.
Do we have any other discussion about the fees and the methodology?
I'm good, Madam Chair. Thank you.
Thank you. And thank you guys for volunteering to work on that committee. All right, we're almost to the end. Item number 10, discussion concerning the potential impact of COVID-19 pandemic and potential budget cuts may have on future council and board meetings.
Madam Chair, I had a couple questions here, please.
Yes, sir.
My main concern around this one is, once again, goes back to the citizens of the state and honoring one of our fellow board members of the great state of Texas. And what what I would ask is, how far behind are we falling in investigations? Are investigators able to do their jobs from their houses? Do they have that capability? How far is the backlog of cases going? What is the plan to get us out of the backlog? What I'm looking for is kind of to understand the overall situation as it relates to applications, investigations, and the timeframes to remove us from a very bad situation potentially.
Daryl, do you have that information?
Okay, I can speak to, let me speak to the applications issue first. Right now, the only backlog it looks like that we have is on the social work the social worker side. If you, and I think I included in your materials somewhere earlier up under the applications processing stuff. There was information that showed you that basically there's no backlog in the other boards on applications processing. And Tim,
How about social works, Daryl?
it was like 300 and something days.
If you don't mind, Daryl, I'll jump in. This is Tim.
No,
Burke.
I don't mind.
Wanted to talk about this, and before I start, I certainly don't want to I don't want to be negative toward the staff at HHSC that's helping the social work board, and I don't want to be negative to Mr. Spear either. But on the 29th of May, there were 394 backlogs for exams and licensure upgrade. And I and other board members are getting calls, if not daily, multiple times a day, about individuals concerned that they're about to lose their jobs because they can't get their license renewed or be approved to sit for the exam. And so I really feel like we have a crisis at the social work board. I'm happy that the other boards are not experiencing that, but also a little dismayed that the social work board's the only one experiencing that. People are reaching out to me, and of course I'm responding and asking Mrs. Bradford to help, and she's very responsive and helps individuals. But this is problematic for the public that we're trying to help if we're not licensed or having an issue becoming licensed. This is a problem for the discipline and a significant problem for workforce. And I know that not only are the board members getting contacts, the professional organizations are getting bombarded with these. And so I have made over the last year multiple attempts to offer. There are outside resources if HHSC would just reach out to that could take care of this backlog in less than 2 months. And I know that BHIC is going to come in, and I keep telling them, please wait for BHIC, please wait for BHIC. It's going to take care of this, because I know, Daryl, you and your staff are, going to focus on this. But I feel like we're in a crisis situation. I know it's been a couple of weeks since the 29th of May, and I know staff are now getting computers to be able to work at home and hopefully process some things, and they're also, staff are being allowed to work on the weekend. But this is really egregious, I feel, and something, we've got to have some kind of a plan to take care of this. And I'm sure this is probably not the right forum necessarily, but this is really out of hand.
I'm curious, do we know why the impact is so heavy on the social work side of things?
I don't know if it's because of the number of licensees. I think we're a little over 26,000 at all levels. I'm not sure how that compares to the number of other licensees, but I'm not certain, really.
Mr. Spinks?
Yes, sir.
Do you have the answer of why it's only impacting one of the member boards and not all the member boards?
I do not know.
Okay. Are you in agreement with the numbers that Mr. Brown is stating?
Yes, sir.
That's what you're seeing also?
Yes, sir.
Okay. So I'm curious to know your thoughts of the plan. Is there a plan at this point, or does a plan need to be formulated, or what are the thoughts about this?
I visited with Mr. Spear, I guess it was when he was over here doing UAT testing. We visited, I know HHSC has now authorized weekend overtime. I think based on my conversation with him, he was anticipating having the backlog either reduced or significantly reduced by the transition date of BHEC. If we're wanting something sooner than that, if if we need to get something done sooner than that, then I'm going to need to visit with Tim and see if we can't triage the problem and find out what's causing it on the, because I don't know what's causing it on the social work side.
I mean,
Tim Spears on the call. Tim, do you want to say anything about this?
Tim, are you there?
You may not know he's on mute.
Can you hear me?
Yes,
now
sir.
we can.
Okay, I was unmuted on my phone but muted on the computer. So
Okay.
no, I definitely want to discuss this because, as Chair Brown mentioned, it is very much a problem, and it's very much on the front burner for us in the office. The reason for why this is a social work issue more so, or only a social work issue as compared to the other boards, is there are some complexities involved with social work processing that don't exist for LPC. LPC and social work are both roughly equivalent as far as the number of licensees are concerned. They both have about 26,000 licensees. The difference with social work licensing compared to LPC licensing is that there's a two-step process where staff have to approve somebody to take an exam that's administered by a private party and then approve somebody for a license. So that's one of the big differences. We've had staffing issues since September of last year that we've been trying to work through. And the social work backlog has ebbed and has waned and waxed since about September of last year. We had overtime approved back in late January. We began making significant progress in February, and then COVID hit and we lost all of the progress that we had made. So we've had basically a litany of adverse occurrences that have led us to where we are. What we've got going now as far as the plan to resolve this for the future is that we have gotten approval for weekend overtime. We've got laptops for everybody, so improved processing can occur during the week. We've also got approval for temporary staff, and so we've begun bringing them on board. And it is our belief that with those resources, we should be able to make significant headway into this backlog moving forward. I would hope that by the time we transfer, it will be down or close to zero.
So, Mr. Spear, a couple questions, please. One,
yes.
Is this work, the approval, the two-step approvals, can that be done from somebody's house versus being in the office?
It depends on how the person applies, and parts of it can be done from home. Some of it has to be done from the office. We are, unlike the psychology board, we are much more heavily dependent upon paper. And so there has to be some time in the office to be able to locate that paper. We don't have the staffing or the resources to be able to image all of the mail that we get. To give you an idea, I spent probably 4 hours yesterday just opening mail.
Wow.
So at this time, are and forgive me, are the state offices partially open? Are they shut down totally, or is there
we have a social distancing protocol whereby we have 20% of the staff in at a given time. So basically that means each staff person is in the office 1 day per week. And so when they're not in the office, then they take work home and perform it there. Previously, up until about a week ago, a week and a half ago, they were having to do manual hand processing and then come back in and data enter it. I could go into a long spiel about the technical issues that we had, but it's just suffice it to say that many of the assumptions that we made as far as what we would be able to do technologically turned out to not be accurate.
Is it possible to reallocate the staff since you're 1 out of 5 days? Is it possible to bring the staff that work on the licensing specifically for social work in and then have everything else processed from people's homes now that they have the notebooks? And then that way you're able to get through the mail faster and the imaging?
We can look into that. The problem is that we also have schools that are out and daycare that doesn't exist. And so people don't have the ability to come in as easily as they used to. So we can look into that. What we're doing is we have people coming in on the weekends, and we have people who, everything that we do on the weekends is social work. We're not using the overtime for any other program. It's all social work focused.
Let me add or chime in on the LPC stuff, something that, because we are roughly 26 to 28,000 people. Some stuff we did last year, because we also experienced a backlog. We opened up some of our testing. We used to just take the national counselor exam. Now we accept the national clinical mental health exam. So there's 2 different types of exams that people may have taken. We accept those. We also streamlined our supervision forms, got rid of site location forms. We made the process a whole lot more streamlined, and I think by creating that, it made it easier for staff to be able to process some of our stuff. I don't know what the situation is, for social work, but we saw the issues, and we made some things a little bit easier for everyone, staff included, and still maintained, the integrity of the process. So we were there, and we're doing pretty good right now. The staff says that things are rocking and rolling pretty good, but by creating an avenue for taking out some obstacles, it helped us out a lot.
And also we followed that matrix system that helped to clear a lot of backlog.
Mm-hmm.
So, Chair Smotherman, I guess I would like to see 3 things, please. I think A, the plan for a revised process, right? I think that we have to look at the efficiency of a 2-step process versus a 1-step process. And what does that mean? How do we change that? How do we impart that change? And the reason why I ask that is because we all know that with the numbers, that's what got us all together in the first place. I got to meet you fine people. So I think we probably need to do that. Number 2, a plan for removing the backlog and the associated time frame to see that backlog drop. I think we need to do that so that we can communicate that and be transparent in what we're doing to our stakeholders to make sure they know that we recognize that there's a problem and that we're working on the problem. It's published on our website and we're showing them what's happening. I think we have to be as transparent as possible. Otherwise, this is going to blow up on all of us. Number 3, I think we need to plan for a second closing. I mean, the advice that I'm receiving in my business and from our economic and social planners is that we're preparing for a second closing. And I think we need to have that same thought in mind. Hopefully it doesn't happen, but if it does happen, then at least we know what we're going to do so that we don't incur even more backlog and get into a bigger situation than where we currently are. And so what I would ask our executive director to do, Madam Chair, is to present these 3 things to us so that we know that this situation is under control and being taken care of. That would be my recommendation.
George, do you have a time frame for that?
I don't have a time frame to see these things. I'm open to what the suggestion of my peers are on this council. For me, I'm aggressive. I'd rather see things sooner rather than later. And so in my world, when I hear board members are getting calls multiple times a day, that to me says all hands on deck. There needs to be a plan within the next week or the next 2 weeks at the latest. So that would be my internal response. Now, my good Chair Smotherman has taught me to temper my humanistic side
and to be more civil in nature. So I would probably say within the next 3 weeks, we probably need to see something.
Oh, I was going to suggest a month. Mr. Spear, I just would like to suggest that for LPC board, we give the staff a little more authority to take care of things without checking back with us and wait for the meeting. If that happens, would this speed up the process?
Dr. Abraham, that is not what is at issue with this. It isn't board related. So the board meeting issues are going to be for very specific individuals, not for an entire class of people. And it isn't what our impact is right now. Our impact is staffing, volume, and the social distancing requirements that are in place.
Is there any way we can do like a priority, like people who are going to lose their jobs or something like that? That process can be speed up.
Tim?
I'm not sure I understand what you're saying.
Make a priority list. Like somebody mentioned that people, because of the licensing process, they're going to lose their job. So that is very important. Can we give it a priority?
I understand what you're saying now. I thought you said something different. We handle these applications in date order receipt because that's the fairest way to do it.
Tim, this is Daryl.
Sir.
I'm looking under the social work statute. Y'all have got a very unique provision, this temporary license. This thing seems to be geared towards almost, I mean, I don't know. It looks like it's geared towards kind of maybe this type of a situation.
Well, it's problematic because we have to make sure that everybody who is who has applied for the temporary license is eligible to take the exam. So we're backlogged on that portion already. So if they've applied for a temporary license and we haven't determined that they're eligible to take the exam, then we can't issue it until we get that step taken care of.
If I can, Daryl, the temporary license is for individuals who are in their last semester of either their BSW or MSW. And if the dean of the school or the chair of the school of social work where they are writes a letter and says, this individual is considered at this point will graduate if they continue the way they are. This allows that individual before they're actually graduated to sit for the exam. And then there's a period of time where, I'm getting it confused. This is for individuals who have graduated but have not sat for the exam yet. And so this gives those individuals the opportunity to be licensed for 6 months while they're trying to pass the exam. If they pass the exam, the temporary license goes away and then they're fully licensed. If the individual fails the exam, then it goes away because they've proven they don't have minimal competency. And so a lot of times when someone is working on their bachelor or their master's, they have a period of time where they have to have an internship. A lot of times once the student is in the placement, if they do a great job, then the employer wants to hire them full time. And so this allows them to have the job, be temporary licensed, and then be able to sit later for the exam. That's what this particular license for. It's not where we can just piecemeal it in anywhere if someone's license expires. Does that make sense?
Yeah, but I think that would even slow down the process. We are trying to catch up.
Correct.
Give them
I'm
temporary
just explaining
license,
what it is.
and it's going to slow down the process even more.
Mr. Brown, if
yes.
Tim mentioned that the prioritization is based upon the mail, first in, first out, the FIFO method. Based on what you're hearing, do you think there would be a lot of concern if that methodology was changed to those who are closest to losing their license, or those most likely not being able to practice that are already practicing, having those processed first?
I think it's a slippery slope, and you're kind of sharing, I say it's important to people to have their license renewed. I'm not saying it's not. But I think if you start moving people around of having prioritizations, that may be problematic, and then you have individuals saying, well, I'm just as important as that person. I think what will be great going forward, and I believe Mr. Spinks has set this up with the psychology board, is if we shift people rather than doing all this snail mail, where it has to go through 3 or 4 mail stops before it gets to the licensing department, if we can funnel people into renewing online and it being kind of an automatic thing, I think that'll take a lot of steps out for a high percentage of the individuals.
And that's what I was asking for in the first thing, the plan for a revised process. I mean, clearly we have to move away from paper, and clearly we have to drive people towards our website, towards electronic processing. It's the only way that we can do this. I mean, we're not going to get ahead of a paper game. And so that's what I'm asking for in step 1, planning for that revised process. Then we have to do the emergency problem that we have at hand, which is planning for removing the backlog. I mean, there we need to simply graph it out. How many weeks, how much can we process per week? How many weeks are there based upon the number of people that we have? There's got to be numbers put to paper. What does that look like? And then we have to track to see how closely we're following to that plan. And then the third one is planning for that second closing. We have to realize, what have we learned from the business being shut down because of COVID-19, so that if it happens again, we know not to make the same mistakes and how to be more efficient in the second closing than we are in the first closing. If I have support, Madam Chair, I would like to make that motion or request it, and so that we can move forward. And I think everybody knows what needs to happen here, and so that we don't belay the point and people can get back to work. But would it be more appropriate to make a motion, Madam Chair, or is it more appropriate just to request that from the executive director? I'm not quite sure.
I think it's fine for it to be a request unless you need it to be a motion. And I think also, I'm looking at Daryl's head as well. And I think also this is something that Daryl's gonna definitely need Tim Spears' assistance on, because right now Tim is over there, and then we'll be over operations once we move over. So I want to see this dealt with, and I know I want to make sure that BHEC is moving forward on our timeline at the same time. And so I want to, if I could say, maybe it's not just on Daryl to do this, but to be able to delegate that to whoever it is that it makes. And I don't know if that's Tim Spear or not. You guys figure out who needs to do that in order to get it fixed,
And the only reason I said Daryl is because I don't know that we have authority to direct something to Mr. Spear, but we do have authority. Yes, but we do have authority for Daryl, and then Daryl can figure out who the right people are to make it happen. And I don't care who it is. I just care that it gets done and it's reported back. And then to Dr. Abraham's point, in terms of time frame, I'm willing to go between my 2 weeks and her month and go with 3 weeks. And what I would like to see is either a meeting called in the 3-week time period, as you say in all the writings, telephonic or a Zoom meeting, so that we know the progress and we know what these plans are. So to have Daryl come back to us in 3 weeks time period is what my request would be.
Daryl, is that okay with you?
I know it's a lot.
It's a lot. Yeah, I'm not gonna lie.
No, it is. Trust me, everyone's doing this. You're not the only one in this situation. You're not the only one. Everyone is.
We'll do it.
Thank you.
We'll do it.
Daryl, we are glad we hired you. You get things done.
Part of me wishes we were already in BHEC, because I think we'd be a little more nimble.
Yeah.
than having to deal with HHSC, but it is what it is. So we'll do what we can with what we have where we're at and see.
To clarify, George, I don't think that we can hold another Zoom meeting to discuss this. It would have to just be an email or some kind of report, Daryl, that you send out to us. Isn't that correct?
Well, I mean, as long as the governor's disaster declaration holds out, it's good to July 11th.
Yep, we can do it.
That's within the 3-week time period. It's just here's the hard part: getting the 9 of you together. Y'all are the hard part to that. But we can start working on that.
So
great.
2 questions, please. Mr. Brown, first of all, does this satisfy your needs and does it move towards satisfying your customers?
I believe any action would be greatly appreciated, and the licensees would be most grateful. You know, I do, if you don't mind, I do want to again say, I'm not pointing fingers at the staff and I'm not pointing fingers at Mr. Spear. They're doing the very best that they can with the resources that are allotted. I am a little disgruntled with HHSC because I don't believe that they've supported the social work board. And, you know, we're talking about, this isn't just from the 29th of May. If you look back on what Daryl shared with us, the 24th of January, we had 372. So it does ebb and flow. I just, somehow we need to do something to help these individuals between now and when Daryl takes over, because I know Daryl's going to take care of it. He's got the resources and he's got the drive. We've hired the right man and he's got the resources. So that's my only desire, and I appreciate you asking, George.
The only other thing I think that we really missed is the communication process. And Mr. Spinks, I would ask, based upon your experience and your judgment, what should we put up on the website, or how should we communicate with all the people that are currently in limbo that are asking questions, so that we can get the questions that are getting asked to the board members cut down and cut back? How do we make this transparent so people know that we know there's a problem and that we're working on the problem? How do we communicate that, and how do we make it transparent?
Boil down your action plan, this 3-point plan that you want. We need to boil it down into plain terms about what we're doing and what we anticipate the result of it to be, and put that on the website and blast it out.
Perfect.
I have a question for Mr. Brown on that. My thought as I'm listening is that you're only hearing from people who are calling right now in immediate crisis, but there's more that are going to be coming. It's just going to continue. So does the social work board have the ability to send out a mass email to everyone who's licensed by your board?
Yes. Well, I say we do if we have their email address, and I believe Mr. Spear, correct me if I'm wrong, we do have that ability to send out a mass email, don't we? I don't know that we've ever
we have the ability to send out a mass email. We are prohibited by law from requiring an email address to be provided. We do include the email address as an optional field, and we have what is called a Gov delivery system, where we have people who have subscribed and requested to be included on emails, but we don't have anything where we can safely say that everybody's getting an email. And we certainly don't have a way to send out emails to prospective applicants.
So my question would be is if we could maybe do the communication as a layer or 2 different opportunities. You know, it can be on a website, but they got to go to that. They may not even know to do anything. And so I'm just wondering, since we're looking at this specific to social work, if that could be communicated by the board chair or whoever, just to say very briefly, we hear you, here's what we've done, here's what you can expect, so that we're taking it to them instead of waiting for more people to come to you, just to try to cut down on people contacting the board members.
We can also send it out to the professional associations. They've been good in the past about sending emails out to their membership as well as putting it on their webpage as well.
Because we're anticipating the need for other people that haven't reached out yet. And I just think that'll assist with being more efficient with what we're trying to do, and also show the effort that's put into place. So I want to make sure that doesn't get lost.
Thank you. Dr. Abraham, did you have something you wanted to say?
No, the second portion of what Tim suggested was excellent, like putting it on the organization. Like for us, we have TCA and things like that. So that would also send a message out.
Okay, very good. Good. Thank you, guys. I know we just have a couple of items left on our agenda, but I'm also looking at the time. Would any of you appreciate a 5-minute break?
I'd like to get a cup of coffee.
Okay, let's just take a short break as quickly as you can go and come back. And if that's 5 minutes, then that's great. If it's 10, take 10, and we'll come back together as soon as we can.
Tell you what, Sheriff Smotherman, could we have a time to come back that way?
Yes. Yes. How about we come back at 3 o'clock?
Okay.
Okay. Thank you.
Sarah Abraham.
Present.
John Belamowitz.
Present.
Timothy Brown.
Present.
Steve Christopherson.
Present.
Dr. Susan Fletcher.
Present.
George Francis. Ben Morris. I'm sorry, I see Mr. Francis just joined us. Mr. Francis.
If I can catch my breath back from the stairs, present.
Awesome. Jennifer Smotherman.
Present.
Okay. I don't see Mr. Morris back on the call, and I will note when he rejoins, but you have a quorum. I'm sorry, Mr. Morris is there.
He's up there.
You have a quorum.
Can you see the chat?
Thank you.
Okay.
I see you.
We see you up there. Thank you everyone for coming back. We are on item number 10, and we had a great discussion there. And thank you everyone for having that discussion and taking up the concerns that are related to one of our member boards. If it relates to one, really in this kind of a situation, it relates to all of us. And thank you very much for taking the time to have that discussion and for coming up with a plan of action. Let's continue on item number 10, discussion concerning the potential impact of COVID-19 pandemic and potential budget cuts may have on the future council and board meetings. Daryl, were there things in particular that you wanted to bring up here? And then I'm curious about other thoughts and ideas that some of our council members may have.
I had originally put this on the agenda out of fear of that 5% budget reduction plan because I felt like that was going to impact, separate and apart from the COVID-19 stuff, I felt like that was going to impact our ability to meet in person. With the exemption from the 5% reduction plan, I no longer have that concern for this biennium. But what I'm kind of needing to know from you guys is, I don't know what y'all's comfort level is with traveling. You know, whether you want to continue to do meetings like this. I know the meeting we're going to do here in about 3 weeks will be like this, but beyond that, like your August meeting, are you going to want to shoot for an in-person? Do you want to keep doing it this way? Assuming we can, technologically. I just wanted y'all's feedback to see what you thought, what you like, don't like, how you want to do it.
I think it saves the state a lot of money if we do Zoom. There's no travel involved that way. It doesn't really affect me. I stay with a friend in Austin, so but still, I think it would save a lot of money. But I can go either way. I'm easy.
I think it's important that I think it's good that we have in-person meetings in the seat of our government in Austin from time to time. I don't think this is something that we should do in perpetuity. If it's something that we do to augment in-person meetings, or if we do one or two in-persons a year and the rest are Zoom, I think that in terms of what this does to save the state money, I think is good. It feels like, and I would love to hear from the public in future meetings what they think about this. If they feel like this is more open, if they feel like their government is more open and more accessible via Zoom, and their ability to participate and not just watch us on YouTube, as we've had the benefit with our meetings at TDLR. But I like this. I think it's generally good. I'd be curious to see what other people think too.
I love you fine folks, but I'm not looking to increase my risk of something bad happening and meeting with you in person for the next meeting. I think if we wait a little bit longer, we shall meet again, and I think that will be okay. And I love your idea of hearing from the public. We have the chat window at the bottom. I would ask anybody that's listening to the call or that's engaged in Zoom to go onto the chat and to provide your feedback. We might not discuss it at this session because we're outside of public comments, but at least we know what people are thinking, and that can be reviewed later on. So that's my 10 cents on that piece of it.
I agree with most of you guys. I think August we should do the Zoom meeting and then the next meeting onwards in person, because both have its benefits. Seeing, the public face to face, and then they're talking to us and we're giving a response is really better than this virtual. But considering the safety of the board members, the staff and everybody, probably August Zoom meeting would be okay with me.
I would just add that I would support an August by Zoom, but I too do like the in-person periodically. I'd hate to see us abandon that. The in-person allows us, I know at one of the last in-person meetings, I was able to ask something of someone that had made a public comment, and it was really helpful to get some clarification on some things as we were discussing that item on the agenda. So I think that we've learned that this works, this is an option, and that it is an option as we go forward. But after we won't have any effect on anyone's health, hopefully, I think that it would be good to do in person. I don't want to abandon that at all, even though I do have to travel, and I appreciate when I don't have to travel.
I concur with everyone. I do like the opportunity to be with others, especially our stakeholders. But I think for everyone's health and safety, even if we don't have a severe reaction, if I pass something on to somebody else, I would feel very poorly about that. And so I think as soon as it's safe to come back together, I think we should come back together at that point.
Well, I concur. I think now's the time for common sense, and we know this can work, and let's let it work next time. But having said that, after today, I cannot wait to meet George Francis in person.
I'm overrated, trust me. Ask John. I'm highly overrated.
No. Daryl, do you have enough? Do you have a consensus there?
Yes, ma'am. Yeah.
All right.
We'll plan on a Zoom meeting in August.
Okay.
Madam Chair?
Yes, sir.
We're still on item 10. I do have another item, please.
We are.
Okay. Being in Austin, there's not a company in Austin that's not cutting back, either in terms of layoffs or like my company, Dell, you've read in the newspaper, they've cut our retirement. They don't match our 401ks. There are no promotions this year. There's no pay increases this year. We've let go of contractors. And that's at Dell. And as you saw, we had a spectacular quarter last quarter. But all the economic views say that Q3 is infinitely worse and that there are strong headwinds in the marketplace. And so that's the same with Apple. That's the same with Samsung. There's just not a business in Austin that way. So my question to you, Mr. Spinks, would be, what are our forecasts? And have we started looking at and projecting what happens if we have to cut back 5% of our staff or 10% of our staff?
because clearly these businesses are the ones that provide the revenue, except for those that have sweetheart deals to the state, along with the University of Texas, which is changing the way they're doing their educational system. They're not going to have as many students come in. Everything points to that there will be cutbacks. And so my question is, what is our plan if that happens? How are we modeling it?
If you recall from earlier on in your board meeting packet, I gave you our proposed plan, what we were going to implement or what we were going to submit to the governor for a 5% reduction. That same plan will stand, except for if we go into the next biennium. Jenny, can you hear me?
Yeah, I'm here.
Jenny, the temporary investigators or the temporary staff that we were cutting as part of that 5% reduction plan, did they extend into the next biennium, or was it just this biennium?
They extend. So the temporary investigators we have for 3 years. The receptionist, we just have the one for fiscal year 21. But yes, we carried over any staff cuts, into the next biennium.
The reason I mentioned that, Mr. Francis, is we would still have that money in the coming biennium. If we're forced to do a 5% reduction, we could still basically follow that same plan. Now, being a regulatory agency like this, you will notice if you look at our budget, most of our budget is in staff salaries. So once we go beyond 5%, let's say we get into 7.5% to 10% range, at that point, you're going to start cutting into the meat of staff, and you're going to have to start letting staff go.
And so I fully expect that. And so my question is, if we let 1, 2, 3 staff members go, what does that do for the overall backlog and the processing of applications? Assuming that backlogs and applications don't change pace, that they're at their steady run rate, how badly are we impacted? How quickly does the backlog build? And what are we looking at?
I don't have all that information. I can't answer all those questions for you. The only thing I can tell you is it will be a significant impact, a negative impact on those numbers. You're not going to hit your performance measures with the loss of that many staff. So I'll have to look at it and see if I can't come up with some better estimates on what it will be, or what I think it will, what the number, what the actual consequence will be. The only thing I can tell you is it will be a negative consequence.
And I guess,
well, I was just going to say, when we submit the LAR, that is part of the 5%, 10% budget cut. I fully expect that we'll have to do a 10% reduction schedule, but they do ask for those numbers. So we will have to prepare the numbers as to how it's going to impact our performance measures.
I guess the second part of that is, when you're looking at it, are you looking at it from the perspective of that we cut investigators, thus we have caseloads that build up? Are you looking at it that we're cutting staff that process applications? I guess I would want to know, how are you prioritizing what those cuts would look like? And based on the reason why we were formed in the first place, are we looking at it from a political perspective also of how will this be perceived? Is the organization being successful in its charter, or are we going to start really failing in the eyes of legislators, right? And most importantly, are we failing in the eyes of protecting the citizens, depending upon how we cut and where we cut? So I'm looking for an overall plan that would show who gets cut, where do we cut back in our business, right? What area of our business suffers the most, and how can we suffer the least and protect the citizens the most, right? How do you protect your customers and try not to kill the business off? That's what I'm.
May I chime in here real quick? And I respect the question. I have some aversion. It sounds like we're trying to ask who's a priority right now, and for a list of who's expendable and who's not. And I think everybody that's here has a pretty important role to do. And I'm a little I don't know if for the fact that the legislature and the governor did not ask for a 5% cut. I think this is the first state agency that we've created in like 10 years. And I think it's a vote of confidence in us as a board and the mission that we're after here, for the fact that they did not ask us for those 5% cuts. So to start putting on paper who's expendable if they ask for more, I'm not sure that's the right discussion at this point.
I think we should cross the bridge when we come to it. I don't think we should make any kind of
And I'm not
decision.
looking for names or people. I'm looking for what programmatic areas would have to suffer. And what does that mean for the overall business and our constituents? That's what I'm looking for. I never look at it from an individual perspective. That doesn't matter. What matters is our programs, and then you go from there.
I think when you start even naming programs, the staff knows what program they work for. So it doesn't take a rocket scientist to figure out, you know, in terms of demotivating people. I just don't think that's a fruitful conversation, especially when other agencies are asking for, the governor's asking for cuts from other agencies. He didn't ask for it from us. I think that sends a message of what the governor thinks about mental health in Texas. And again, I just don't think that's a fruitful conversation right now.
So your suggestion is that we should wait until the government closes again and then have the conversation of how it impacts us?
No, I'm not suggesting that at all. I'm just suggesting that based on asking for a prioritization and hierarchy of what job functions are expendable, if push comes to shove, I just don't think that's a fruitful conversation at this moment and in this forum.
Let me rephrase it then. I'm open for your suggestion on what we should be discussing in terms from a business decision and our charter protecting the citizens. How would you like it to be framed up so we know how to proceed and move forward?
I have a question here, John, and I'm curious, and I want to hear what you have to say. I don't mean to interrupt here, but I'm curious. What struck my attention, Ms. Nowak said that we have a 10% reduction schedule that we have to present to the LAR and show what the performance measures would look like if we had to implement that. Is that something that would fit right here into this part of the discussion? Like, it's something that we're already having to do, and does that fit right here? Is that something that's completely different?
No, that sounds like that may fit. I guess that's not the question that really I heard being asked.
And let me clarify, we don't have the LAR instructions out. I just, in the past, 2-3 bienniums, we have had to prepare that schedule. And I foresee it coming, but the instructions are not out. So it's not don't take that to heart.
Okay.
So based on your comments, John, let me say this. Is it something, Ms. Nowak, that we can see in our next meeting what that proposal would look like or what the recommendations would be so we can start to understand a material impact on the business?
The legislative appropriations request will be due in August, so probably early August. So I would say yes, if that schedule is part of the LAR, then you would definitely see it.
And I guess what I'm asking, fair enough. I'll leave it alone at that.
Other thoughts or questions, discussion regarding the potential impact of the pandemic? One thing I'm curious about is the issue or the impact. I know one of the things that's happened is we've had to have people go home, that staff hasn't always been able to do all of their work from home. And my understanding, which may be completely wrong, is that part of that's to do with the technology resources that we have. And so not having enough laptops or whatever that are loaded up to take home and do the work being one issue. And then two, not necessarily having access from home to the databases that they need in order to do the work. And you, Daryl, Tim, y'all correct me if that's completely wrong. I'm wondering, is there anything that we can do to plan for the potential that either we continue to linger on like we are with staff only being able to come in 1 day a week, or, you know, we get back open and then they go back down to this. Is there anything that we can do to plan for a second closure?
I think what you're asking the same thing that Mr. Francis had brought up whenever he mentioned that 3-part plan. I
Okay.
think if we develop that plan, we'll answer your question.
Okay.
And that's just something that my staff and I are going to have to go visit with Tim and his staff, and we're going to have to sit down and see if we can't figure this out. And then come back to you within 3 weeks. But we should be able to, I feel like your question will be answered whenever we prepare that plan.
You know what, Daryl, you're right. That's exactly what I have written on there, the plan for a second closing. I don't know that, I guess my question is, do we have the access to technology, and can our staff access the databases that they need to do, or do we need to somehow reach out, I don't know, to get our staff what they need?
Tim, do you want to speak on that?
Yeah, I can chime in. The problem that we had is directly related to the transition from DSHS to HHSC. We are in a DSHS building with DSHS servers, and we thought we would be able to use a particular software that we ended up not being able to use because we have HHSC credentials now, not DSHS credentials. In regard to ability to connect with the network and all of that stuff, from an HHSC standpoint, we've been able to, within the last week, get that resolved. I think there's a lot of putting the cart before the horse right now when talking about what BHEC is and isn't able to do, because it hasn't even gone online yet. And so it's kind of hard to project what will happen on something that's never been in existence. I do know that Jennifer and Daryl have been very forward thinking in making sure that they only purchase laptops for people as opposed to desktops, which will allow better mobile computing, et cetera. So this is something that's been on their radar from the get-go, especially given the challenges with working downtown. I think the problems that we've had at HHSC are not going to transfer with us to BHEC, if that's kind of what you're asking.
That's good. That's excellent. Okay. Any other discussion?
Is that what you were asking?
Yeah, it is what I was asking. And you know what, Tim, you've answered that question for me before, and I had forgotten the answer. But I think it's good that everyone else hears that answer, that there was basically a breakdown in systemic communication between the DSHS services and technology and HHSC. And so with that being said, if we had to go home again, if our staff had to go home again under a new system, it probably would work, and that's great. So good. Any other discussion or questions on item number 10?
I just had a follow-up. I think there was mention of people who are still with us watching the meeting, that they could make some comments in the chat. The chat may be disabled. I just noticed there's no comments in the chat. So I think there was a invitation that through a method that's not available. So Mr. Spinks, what would you recommend if somebody, a member of the public watching us right now, has an opinion about watching Zoom or being present? Are we still inviting?
You can try it now. See if it's activated.
Yeah, it says type a message here, so it's activated. And just test it.
Dr. Fletcher, thank you for taking us back to that point. I appreciate that. There's a test from the chat. It is working.
Great, thank you.
The attendees should be able to send in chats as well. Yes, there's Miss Mulware. She just.
don't know. I just felt like we made an invitation. We gave an invitation, but we didn't give the opportunity. So I want to make sure we do that. Thank you.
Yes.
Thank you for the follow-up.
Cool.
Okay. Daryl, can you see those comments that came in?
There's several that are coming in.
Okay.
Let's see here. Yes, I can see them.
I tell you what, while those are coming in, we can circle back to item number 10 as it relates to our meetings, our future meetings. But as those are coming in, let's move on to item number 11, and then we'll come back to take a look at those as they, and really the comments we're looking for had to do, if I understood it, the invitation correctly, it was comments related to having our meetings on Zoom versus having our meetings in person. Is that correct?
Yes.
Just to clarify. Okay. So we'll circle back to that here in just a minute, come back to item 10, but let's move forward to item number 11, which is the report from member boards regarding current or future issues that may impact the profession or the agency's regulatory functions. Member boards, do you have anything that you'd like to say? John, was that you?
I have something. I've been thinking about this in light of current events, more having to do with policing in America, and the crossroads of mental health, policing, and it's a crossroads of a lot of things. So without getting into the policy of it, I'll leave that to people who are a lot smarter than me. It feels like a lot of this is coming to our doorstep, whether we like it or not. During this meeting, I don't know, about an hour or two ago, I got a news update headline. I'll read the headline. Albuquerque to send unarmed social workers, not police officers, to some 911 calls. So that's what Albuquerque's doing. As this conversation happens nationally, in different localities and different states do different things. I have no idea what, different municipalities and policing entities in Texas will do. As an agency, I don't really feel like it's our role to set policy in this regard. I think it is our role to make sure that we don't stand in the way of something. So I don't know, I don't want to give anybody any action items or anything else, but to be thinking about and to be aware of and just keep it on our radar of what things in our rules could either facilitate or hinder things in this realm, to make sure that we are not a hindrance if police departments are going to do something that would involve potentially people that we license.
Thank you. Anything else from member boards?
LPC board is excited about going forward. Feel like we're a pretty well-oiled machine, lots of good communication, people working together. We'll come together and feel happy and confident to be able to put forth rules. They're going to be heard. Really appreciate the support of our associations and their input and their guidance too. So just a shout out to everybody that helps us out with that. So you're definitely crucial in the entire operation. And thank you, Daryl, for everything that you do.
Thank you, Steve.
And this is Tim with the Social Work Board. Beyond what I shared earlier about the concerns for the licensing, I really don't have anything else. Just want to publicly thank Tim and the staff that are there with us and all the good work that they're doing that are allowing us to move forward. Appreciate Daryl and Patrick visiting with us over our rules, make certain that we're in alignment with the BHIC. So thank you.
Thank you, Tim. And I'll report from the MFT board. I echo, Tim, what you just said in terms of thanking Patrick and Daryl for helping us as we've looked over all of our rules. We've gone through that process. And a huge thanks to Tim and to Sarah, our executive director, and the other staff that have helped with that process. That's been a huge undertaking. And I feel very successful that we got it done over the phone. We didn't even have the video to get that done. And so I'm grateful that we've all been able to collaborate in that effort and in that process. So thank you guys. I'm also very excited we were able to announce that Sarah was coming over with us. And I know since that point, we've had many other staffers who've been hired over at BHEC. And so I'm just thrilled. And I know our board members are thrilled that those people who already have the institutional knowledge and know how to do the job well are going to be our boots on the ground on day one. And so we're very happy about that. Anything else from the member boards?
I just have a question that I think would be helpful if Mr. Spinks could just review the next step for those that are still on the call with us. Now that we have dealt with and reviewed and proposed the rule changes for the 4 boards with what occurred today, Mr. Spinks, could you just review for people still watching what the next step is, what they can expect with what BHEC just did with that today?
Sure. Those rules will now be published in the Texas Register for public comment. Once that public comment is received and the comment period is closed, we will then forward those comments down to the member board for it to consider at its next meeting. It will then need to decide whether or not it wants to make any changes to the rules that were proposed or to issue a recommendation that the council adopt the rules as proposed. And then it will let the council know what to do. And then the council at its next meeting will then decide whether or not to adopt the rule. Oh, and in the process, we'll also, we'll send it over to the governor's office for review over there as well. But the public should have the opportunity to comment in the Texas Register. You'll have the opportunity to comment again at the member board, and then again at the council, should the board choose to recommend adoption. So at least 2, possibly 3 more opportunities to comment on the rules.
Thank you.
I'm not asking for a date, Daryl, but do you have any kind of a vague timeline for when they can expect, so they know when to be looking for these rules in the register?
Well, I'm going to prioritize the LMFT rules simply because y'all's board meeting is coming up. I don't know if we can get them published in time so that the comment period would close before the July meeting, but we're going to push on it and see. The LPC, I think maybe psych boards is after that, so I'd have to do their rules. And then the LPC and social work are in September, if I'm remembering right, September the 11th. So I got a little bit more time on theirs, but I got to do LMFTs first if I can get y'all's done so that I can get it out and get it published. That way y'all will have the comments to look at into July meeting. Kind of my game plan on it.
Okay, thank you.
Doing the dance of when things are published and who's meeting next. We'll have to prioritize that.
Thank you. All right, item number, any other comments or discussion on item number 11? Okay, item number 12, recommendations for agenda items for the next council meeting, which is going to be on August 25th. It's our next scheduled meeting, but it sounds like there'll be a meeting in between now and then to review the plans. Anything that you'd like to see on the agenda in August that we haven't already covered?
Madam Chair, I think that we probably should leave COVID-19 on the agenda going forward until we get out of the current crisis. I heard Mr. Spinks state that we're going to leave number, number 6 on the agenda until we get a little bit firmed up on that one. And then we probably will have a meeting of the ad hoc fee committee possibly by that next meeting. So my recommendation is that 9 goes back on the agenda for the next time.
Thank you, George.
You want to report from that committee at the next meeting?
The ad hoc committee?
Yes, sir.
Yes, please. Any other suggestions?
Madam Chair, we will more than likely, we'll have an MFT meeting before then. And so those rules will probably come back up. Don't know whether they will or they won't, depending upon the vote of the MFT board, but I would put that on the agenda for discussion just in case they do.
Yeah,
That would be my recommendation, Madam Chair.
that's a good idea as well. Any other thoughts? All right, let's circle. Oh, go ahead. I'm sorry.
I was gonna say on the rules, if we get them published and you guys get the comments in time, then yes, I'll make sure that's on the agenda. I'm probably gonna hold off on putting that particular item on there until I know for sure that you guys have had a chance to look at the comments. Otherwise, we just got an empty placeholder sitting on the agenda. But if it comes out of your board, we'll put it on there for the August agenda, if that's okay.
Thank you. That works for me. George, is that good for you?
It works for me. I'm perfectly fine with that. Thank you.
Okay. All right, let's circle back up to item number 10 and look at the input that we got from the public on the invitation about Zoom versus in-person meetings, the question about that, and what kind of preference or input we got from the public on that.
I appreciate Kathleen Mills made a comment about a hybrid concept. And I think that speaks to what we heard members of our council say.
I will say this on the hybrid concept. If the governor does not continue disaster declarations, it will be a hybrid concept as a requirement under law. The way it'll work is I'll have to have the presiding officer here with me, and we'll have to open up one room open up wherever the presiding officer is, has to be open to the public. So in essence, you could have part of a facility open, but the rest of you could be where you are now. So you very well, you could easily end up with a hybrid there if Governor Abbott doesn't continue the disaster declarations.
I have a question. I actually kind of like this chat feature. I could see how it could go south in a hurry if it was just left on all the time. But the fact that we solicited a specific question and got actually good answers and engagement is something that I really appreciate. And I want to just say that to the public who's here participating. I really appreciate that. So I don't know if this is a record-keeping issue, Daryl, but
Yes,
I like it. It is? Okay, so maybe we shouldn't talk back on that and just keep our responses here.
Yeah, I wouldn't recommend responding back via chat. Just respond in, in the verbal.
Very good.
Okay.
There's a Q&A function that may be a little bit better for this that I have turned off. That's probably the better way to go if y'all want to do something like this versus chat. We can try that next time.
I think the Q&A would be great because a lot of times I recognize the public may have no idea what we're doing or why. And if it's something even as an agenda item to take 5 to 7 minutes, at some point in the meeting to say, what did y'all want to know? And it gives us a chance to clarify things. I think that's a good thing for all of us.
Yeah.
Mr. Spinks, we have the right to solicit the public or ask anything of the public at any given time. We don't have to answer all the questions that are posed to us. So I like the Q&A feature. I mean, be it Q&A, be it chat, because I think it brings in that participation that we probably miss a little bit, and seeing the facial reactions to our comments in a general session when people say something, outrageous like myself, I guess, I don't know. But I do think that it gives it a more holistic approach if we're using just Zoom like this. I think people have the right to have conversations, and it's just kind of interesting to help us. It's just a guide.
What we'll do is I'll turn on the Q&A for the meeting we're going to have here in a couple of weeks. Of course, the chat's always there. It's just a matter of, I guess, I got to remember to switch it on. But the Q&A, we can turn it on, kind of do a trial run and see how you like it as compared to the chat function.
I would just add a concern, Mr. Spinks, is that I think that the public is still trying to figure out what the scope of our role is. And if there are people who want to reiterate a point that's out of the scope of our role, the chat function could be used for that. And I can appreciate the public's frustration if they feel they've said something in a public comment or in the chat and we don't address it, or they feel as if it's being ignored rather than understanding why we didn't address it or why that's out of the scope of our role. So I know we're on an education curve and probably will continue to be some time, because I think our member boards are also still struggling with that, where people are trying to understand, is this the proper forum for me to have this conversation? I can offer the very obvious example that in BHEC, as well as in the board meetings for psychology, that we have a lot of people who would like to use the public meetings and their public comments or 3 minutes to talk about their specific cases. And I can appreciate the frustration they may feel when no attention is given to that in our board meetings. And we understand it's because it's out of the scope of our role as a board. That is for the complaint process. So I would just want to have some sensitivity for the fact that we're giving another avenue for access that they may not get a response and they may not understand it, and they misperceive that as us ignoring it versus it's out of the scope of what we can do. So I don't know if you want to speak to that for a minute or consider that.
I think that you did a good job of speaking to that, Susan, just now. So that, you know, to clarify, we are able to take public comment, and we are very interested in the public comment and the feedback that we receive from the public. However, the board meeting or a council meeting is generally not the platform to have an open dialogue. And so knowing that we hear those public comments and we consider them as we continue to make decisions and move forward, especially as they relate to our operations and the things that we do. There are, like you were saying, to clarify, there are some things that even in a public comment, if it is about an investigation, if it's about a complaint, that's not something that the board can just take up and take action on, you know? And so maybe, I don't know, maybe it would be appropriate. I know all of our boards sometimes engage our stakeholders at the professional association level, you know, at conferences and meetings. Maybe this would be an important piece, an educational piece about the engagement with the public and how we do that. I don't know, but that might be a really good place to have that discussion.
Chair Smother,
and I'm, yes, sir.
I was going to say, I think you're spot on. I mean, the one thing that the Zoom meeting does is it allows every person in the state of Texas to dial in and watch the proceedings or have comments or speak their thoughts, where it's a lot harder for somebody to come to a meeting in Austin or at some university where we're currently situated. I mean, our participation today, I don't know what our average numbers look like, but it's very high. And Zoom allows you to see each person that called in, the duration of time that they were on the meeting. So we can see where people either lost interest or where they had interest. And there's a lot of things that you can glean from that. So I think you're spot on.
Anybody have anything else on this? Really, we had circled back to item 10, and we were really looking at the feedback that we got about Zoom meetings versus in-person meetings. And I think what I saw from a quick review of those comments is that this works and this is okay, and having in-person, nothing replaces an in-person meeting and the ability to be able to actually see one another, engage. And so I'm hearing that while this works for now, that people would love to see us in person again at some point. Is that a fair consensus based on what you guys read? Yeah.
Yeah.
Okay. And like Daryl said, there may be an opportunity for some sort of a hybrid in the future, depending on the disaster declaration that the governor puts out. So, all right. I think that we have come to the end of our agenda, and we are now at item number 13.
I just wanted to thank you for stepping up. I think you did a great job today.
I agree.
And I certainly want to thank staff for everything that you do. Daryl, and whenever he sends out emails, it's typically 1 a.m. I don't know if you're working late or feeding that baby, but I know everybody's working really hard. And please know that everything that y'all do is super appreciated. Thank you.
Yeah, thank you.
I want to echo the same thing, Daryl and the staff. Thank you for everything you guys are doing.
Absolutely.
We appreciate that. We really do.
All right, guys. Do we have a motion to adjourn this meeting?
Motion to adjourn, Madam Chair.
I'll second it.
Thank you, G4. Thank you, Dr. Fletcher.
Thank you, everybody.
All in
Stay
favor?
safe.
All in favor?
Bye, Steve.
Aye.
Bye, George.
Adios.
Bye, everybody.
Have a great day.
Bye. Everyone stay safe and well.
Adios.
Yeah.
Thank you.